Ready for you, Chair. Chair King, you are muted.
All right, Denise, can you hear me?
Yes, I can. Thank you.
All right, we're ready to go if you are.
I'm ready.
Very well. Good morning, I'm Dwight Keene. I'm chair of the Kansas Corporation Commission. I'm joined this morning by fellow commissioners Susan Duffy and Commissioner Andrew French. I'm convening this hearing for docket number 22-NETE-419-COC on this Wednesday, June 8th, 2022, and it's 8 a.m. We are doing this via Zoom. This has to do with the matter of the application of NextEra Energy Transmission Southwest LLC for a limited certificate of public convenience and necessity to transact the business of a public utility in the state of Kansas. We are conducting this hearing by Zoom and broadcasting to the public on YouTube, so please bear with us if you should experience any technical glitches. Let's turn first this morning to the entries of appearance, and I will begin with NextEra.
Good morning, Chairman Keene and Commissioners. This is Andrew Schulte on behalf of NextEra Energy Transmission Southwest. Also making appearances today on behalf of the applicant are Ann Kallenbach and Sean Pluta.
All right, thank you. Evergy.
Good morning, Commissioners. Glenda Kafer and Trevor Wilford with Morris Lang, Evans Broughton Kennedy Law Firm on behalf of Evergy, and also in-house counsel Kathy Dingus on behalf of Evergy.
Thank you. KIC.
Good morning, Commissioners. Jim on behalf of KIC and the retail ratepayers. Also entering appearance, please, will be Connor A. Thompson and Lee M. Smithyman. Thank you.
Thank you. The Southwest Power Pool.
Good morning, Chairman Keene. This is Heather Starnes with Healy Law Offices on behalf of Southwest Power Pool. I have also participating Mr. Terry Jarrett, who is also with Healy, as well as Justin Hinton and Tessie Kentner, who are both in-house counsel with Southwest Power Pool.
All right, thank you very much. Sunflower.
Morning, Commissioners. This is Taylor Calcara on behalf of Sunflower Electric Power Corporation.
Thank you. Darren McGee and Rochelle McGee Smart.
Good morning, Commissioner. This is Rustin Kimmel on behalf of Darren McGee and Rochelle McGee Smart. Mr. McGee and Ms. Smart appear as well.
Thank you. Citizens Utility Ratepayer Board.
Good morning, Commissioners. Joseph A. Sharp on behalf of the Citizens Utility Ratepayer Board, or CURB. Along with me today are Consumer Counsel David Nickel and Attorney Todd Love.
All right, thank you. And the KCC staff.
Morning, Commissioners. George Evans, Carly Massentine, and Walker Hendricks appearing on behalf of Commission staff and the public generally.
All right, thank you. Let's turn to notice. Does the staff have a recommendation regarding notice?
Yes, staff has examined notice and reports that on April 28, 2022, the presiding officer issued an order setting procedural schedule, which set the evidentiary hearing for today's date. The hearing days were reaffirmed in the Commission's presiding officer order, granting motion to amend discovery order and procedural schedule issued May 20th, 2022. The order was properly served upon all parties to the docket 10 days prior to the proposed hearing date, consistent with the Kansas Administrative Procedures Act. The parties have conferred at a pre-hearing conference and engaged in communications relating to hearing procedure for a hearing on today's date. Staff notes the parties appear today in person, online, and therefore recommends the finding that notice was proper and that the Commission has jurisdiction to hear this matter at this time.
All right, thank you. Are there any objections to notice? Hearing none, I find the notice is proper and the commission has jurisdiction over this proceeding at this time and place. Let's talk about preliminary matters a bit. Before we turn to preliminary matters, though, let's review a few matters incidental to conducting a hearing via Zoom. First, if any party encounters any technical issue today, please ask to go off the record so that we may resolve the technical issues off the record. Second, all witnesses participating by Zoom are asked to keep their microphones off until they are scheduled to speak. Third, if the commission needs to deliberate, we will go off the record. We will enter a Zoom breakout room where you cannot see or hear us. And then upon the completion of that task, we will return. Fourth, as I think all parties are aware, we have a large slate of witnesses who will be called to this in this hearing, 16 to be exact. And I want to be sure to give everyone a chance to be heard. Parties are encouraged to keep their questions relevant to the issues relating to the standards for granting a certificate of convenience and necessity. If I determine that a line of questioning is straying too far from the issues that are relevant, I may instruct the party to try to move on. Parties are also discouraged from repeating questions, that is, asking the same witness questions previously asked by prior cross-examination. Fifth and last, there may be times when we will be considering issues which have been classified as either confidential, pardon me, or confidential competitive. When confidential competitive issues arise, we will move this hearing off YouTube and into a breakout room to consider these issues. Only interveners who have executed confidential competitive non-disclosure agreements found in Appendix B of the Commission's protective and discovery order will be admitted to the breakout room and allowed to cross-examination about confidential competitive matters. When confidential issues arise, we will follow essentially the same procedures so that persons who have executed Appendix A of the Commission's protective and discovery order will be allowed to cross-examine about confidential matters. I encourage the parties and the staff to timely notify me if there are issues that will fall into either of these two categories. Are there any preliminary matters we need to address?
Commissioner, this is Rustin Kimmel.
Yes, Mr. Kimmel.
The McGee's filed a motion for late admission of evidence, in particular, a couple of declarations. The commission has not ruled on that as far as I can tell. So we would like to have a ruling on that for the record.
All right.
Also, for the record, NETE Southwest, I'm sorry, I'm off video. Excuse me, Chair Keen. NETE Southwest has objected to the late filed evidence coming only 2 days before hearing. We've objected on the basis of the fact that there has been no good cause shown as required by the commission's regulations on extension of time, and that there would be significant risk to NETE Southwest and other parties not having sufficient time to investigate the facts that have been alleged, to issue discovery, and to prepare for any cross-examination that would be required.
Mr. Kimmel, I want to turn to you for your response to Mr. Schulte's objection. But before that, I want to make sure we're clear about what we're talking about. These are two affidavits by individuals who are landowners in the vicinity of what is expected to be the line if it is constructed. Is that correct?
That's correct, Your Honor. One of those landowners provides testimony that NextEra entered his property without permission and damaged that property, collected a bunch of samples on it. The other witness testifies of the easement agreement that NextEra has been badgering the landowners with, as well as another access agreement for NextEra to collect some soil samples. That second affidavit, we could forego that if NextEra would stipulate to the admission of the evidence of the easement agreement and the access agreement. We would still like to have the, if that can be arranged, that'd be wonderful. And we could, and then just have further discussions on the rig gear affidavit.
Mr. Schulte?
I'm not sure what the stipulation that was offered was. That we've been in discussions with counsel for the landowners regarding a stipulation, but it seems to be a moving target. So I'd have to rehear and consider what the stipulation proposal was. But regardless, there has been no good cause shown for why this evidence is coming the day of the hearing or 2 days before the hearing. There is no reason why this could not have been filed at the time that the landowners filed their other evidence. And it's highly prejudicial to be responding to not only the late filed evidence, but the argumentative remarks of counsel regarding NETE Southwest's field activities.
Mr. Cohen, let me ask you this question, if I might. As I understood what you were suggesting, and let me ask you, I think I'm pretty familiar with the record, but I believe a part of what's been already admitted into the record by your clients is a draft, I'll say, for lack of a better phrase, of a proposed easement agreement. That is in the record now, is it not?
It hasn't been admitted into the record of evidence. It was attached to as an exhibit to my client's petition to intervene in this case. So it was my understanding we had to enter the evidence into the matter. I mean, it was not attached as part of my client's testimony. Okay. So it was only attached as part of the petition. If the commission wants to consider that as entering into evidence in this matter, that's wonderful. But it doesn't address the issue as to whether or not the access agreement that was attached to the affidavit that was filed on Saturday has been admitted to evidence. I don't think there should be any question that it is a statement of a party statement against interest, so it should be admissible. And I'm not quite clear why NextEra would not own up to sending that or presenting that access agreement to landowners and just stipulate to the admission of it into evidence. Furthermore, I'd like to say that this case, my clients filed their intervention on the 5th of May. I believe it was the 5th of May. The NextEra opposed that intervention, and my client wasn't permitted to intervene in this case until the order came down on the 31st, I believe, of May. My clients issued their discovery within 2 days. Or 3 on that Saturday, I should say. So my clients did not drag their feet. The delay in this case is a result of NextEra's inexplicable opposition to my client's intervention here.
Mr. Schulte, please.
Well, first of all, the applicant was simply exercising the rights afforded to it under the standard commission protocol to respond to requests for intervention. Case was filed in February. Intervention could have been had at any point after the application was filed. In addition, nothing prevented the landowners from filing testimony on May 17th prior to their intervention being granted. We did not object to the filing of testimony during the interim period. We would have entertained data requests during the interim period if those had been issued, but they were not. So we take issue with the allegation that we caused any delay. As to the stipulation, I'm not sure. Again, I want to be clear that if we're stipulating to the evidence, including the attachment to the petition to intervene, which is the standard option agreement or draft option agreement, and then the attachment to the attachment only to the declaration of Mike Weldon, which is a draft survey permission form, then we don't object to the entrance of those two documents into the record, with the caveat that we would reserve any rights to object to relevancy of the cross-examination on these documents, if and when we get there. But only, I mean, that's on a condition of the rest of the late filed testimony being withdrawn.
Mr. Kimmel?
Yeah, first I'd like to address the issue with the discovery that was issued. My clients issued discovery again, I guess on the 1st, the very day that it was allowed to intervene. I don't believe my clients have had the power to issue discovery before they were allowed to intervene in this matter. NextEra, it's kind of rich for NextEra to suggest that they would accept discovery from a party that hasn't been afforded the opportunity to intervene now. My clients still have discovery that's outstanding, and NextEra said that they will provide that response apparently by the close of business today. It's again another attempt to simply drag the feet and prejudice my client. My client can't fully cross-examine a witness until they get the discovery that they issued in this matter. The substantive responses to discovery that they issued in this matter. It's baffling to me why NextEra continues to drag their feet here.
Let me intercede here. We're going to reach a point here. We're going to rule on this what's before us right now. As I understood the offer, Mr. Kimmel, that was made to you just last by Mr. Schulte, it was that NextEra would not object to the admission of the draft option agreement or the declaration by Mr. Weldon.
The attachment only.
The attachment only. That's correct.
My client believes, I'm sorry.
I'm going to admit both of those, and I'm going to a certain extent, accept some of the conditions that Mr. Schulte suggested. Not because he suggested it, because I think it's in the nature of trying to balance the fairness that's involved here. Generally, we're fairly liberal in trying to grant out of leave time requests. However, in this particular case, I think by having the declaration of Mr. Weldon admitted, the draft option agreement admitted as well, and giving your clients the opportunity to testify as they're going to, and giving you the opportunity to do cross-examination as you will have that opportunity, I believe that will be the water's edge of what I will grant at this time, denying the other aspects of your motion. Mr. Kimmel.
Thank you, Commissioner.
Thank you. Are there any other preliminary matters we need to address?
Your Honor, this is Heather Starnes with SPP.
Yes,
Can you hear me?
I
We
can hear
have
you.
we have a couple of discovery matters for the commission's consideration this morning. We have two sets of information requests that were submitted to us on May the 31st and June the 1st by the Kansas Industrial Consumers. On the 31st, we objected to information request 1-05 and 1-06. And we really objected to those on the grounds that they were unduly burdensome and not necessarily relevant, would provide relevant information to the issues at hand. In response to that, Mr. Zakura, on behalf of Kansas Industrial Consumers, asked Mr. Cohen to rule on whether we should respond to those. And he responded yesterday that he felt like that information was relevant. Our concern, Chairman, is that these were presented the very last day that discovery was due. We have been a party for quite some time, and we have responded to discovery appropriately. We did not feel that we could do the work that was necessary to find out if we had any information responsive directly to this, go through the proper procedures to make sure that it was reviewed for confidentiality of the members and participants whose information it might be, as well as look for attorney-client privilege, et cetera. And so based on the timing and the shortened discovery, we objected to those two requests. We continue to object to those two requests. We also objected to Kansas Industrial Consumers request 2-1 through 2-04, as they were submitted a day after the deadline for submission of discovery. We did not initially raise that objection because we did not realize until staff objected to discovery issued the exact same day that these were out of time. We did object that they were unduly burdensome and not necessarily aimed at providing any information that's relevant to the issues at hand. This information that they have requested would take us quite a bit of time to compile. We have 600 employees, and to try to determine what documents we had, review those, ensure that there was no confidentiality or market sensitive information that belonged to our members, not necessarily SPP. This is a lot of our members' information, and to review it for legal concerns and confidentiality, we objected on the grounds of overly burdensome, and we raised the objection now that they are out of time, as Mr. Cohen ruled on the staff's information requests issued on the same day, and we would like that same ruling on 2-01 through 2-04.
Zakura?
Thank you. We do not want to take a position that would be, we don't want to take any position that would delay the hearing. We want to go forward with the hearing, certainly. And so what we would like to suggest is, number one, we believe that, we stand on our position, and that Mr. Cohen did make a ruling. What we would say is that it would be appropriate to give some additional time, as indicated by Ms. Starnes, that she needs to compile the data, with the idea that if it comes in, that we may at least use it for, as exhibits. I wouldn't have the opportunity to cross-examine with it. And I understand what she's saying. You can't do the impossible, correct? You can't do something before this hearing, but I'm looking for a way to compromise that will satisfy all parties, which is basically what the spirit of the order of discovery was, that the parties were to try to work together to get relevant information. So I would reach out to SPP to come forward with some kind of a time limit that would at least let me or let my client review the data before the briefs are due, and that would also permit us to make them as late filed exhibits if appropriate. I would also, Chair, be willing, if there's a manner that Ms. Starnes and SPP feels are appropriate to further limit the matter to make it less burdensome, we're certainly open to that. We're not, we want to try the case. This is a really important case. We don't want to delay it. We want to be reasonable on discovery, and we're reaching out to SPP and to Ms. Starnes to compromise with us in some manner that would allow us to have at least a limited part of the evidence, which the hearing examiner has already ruled to be relevant.
Ms. Starnes?
Yes, Chairman, we appreciate Mr. Zakura's offer. It would have been much more helpful if this had been made when we originally objected to the discovery. We continue to object to 1-05 and 1-06. We are willing to consider visiting with Mr. Zakura about what we could provide and when. However, with respect to 2-01 and 2-04, the hearing officer already indicated that those were submitted out of time with respect to the staff's data requests, and therefore there should be no reason why theirs should be out of time and ours should not. That's not a necessarily objectionable matter. That's just a matter of this was the deadline and they weren't submitted. I am happy to work with Mr. Zakura to try to see if we can provide him some information on 1-05 and 1-06, purely in the spirit of not wasting more of all of our time this morning when we need to get to the substantive matters at hand. But I am not willing to allow and provide for us to provide answers to discovery that was submitted out of time.
Mr. Zakura?
I think there's two issues that I would say here, and I don't mean to belabor this point. With all due respect to the staff and to Mr. Cohen, certainly they deserve great respect. The discovery order is capable of more than one interpretation. And we don't believe it's out of time, but we don't want to delay the hearing, and we don't want to delay this. So we would like on the first group that Ms. Starnes indicated to work with them to get some materials provided with an order from the commission that we can use those at a later time. And then we will certainly on the second group, Chair, abide closely to whatever order that Mr. Cohen and the commission gives with regard to the second group. But our main imperative here is to go forward, have a hearing. It's important for everyone here, and it's important for our state. So thank you so much.
Ms. Starnes, one more chance.
Yes, I would just want the commission to acknowledge that as we are willing on 1-05 and 1-06 to work with Mr. Zakura, we are in no way removing our objection that we do not think these materials are relevant. We raised that objection originally, but I don't think it's in the best interest of the parties or the commission that we spend 2 hours this morning arguing over the relevance and the timing of these particular documents. We will see what we can provide in a timely fashion, but we continue our objection to their relevance.
All right, I'm going to rule with respect to 2-01 and 2-04. I believe there is a concern here about that being overly burdensome, and I will rule in favor of SPP on that one. With respect to 1-05 and 1-06, I'm going to take the parties at their word that they will work together here, and we can fashion an order of some sort so that we can allow. I think just we will allow that by virtue of this proceeding. What was it you were requesting, Jim? You wanted some further. You want something further in the record? Is that what you were requesting with respect to those?
Yes, I was requesting that at the appropriate time that Ms. Starnes and SPP was able to produce the documents, that we would at least be able to mark them as exhibits and add them to the record. And we can then argue on the brief, and that would preserve, I believe, everyone's right, including Ms. Starnes, to argue relevancy. But I would like to have them part of the record as late filed exhibits. And I realize that a little difficult because I haven't even seen what they are yet. but I would like them in the record and part of the record. But by no means am I suggesting that she's waiving her right to object to relevancy or any other ground.
Ms. Starnes, do we have an agreement with respect to 1-05 and 1-06?
Yes, just with the understanding that we will only provide the information that we are able to gather and properly review in sufficient time for Mr. Zakura to be able to include that. Because I don't know the volume of what that information might be, and we have to protect the information of our members and customers.
Fair enough. All right. I believe we have dispensed with that concern. Are there any other preliminary matters to address?
Chairman Keene, this is Glenda Kafer with Evergy. At the pre-hearing conference, I had indicated that my order of witnesses for Evergy would be Darren Ives, Kelly Harrison, and then Steve Vetch. When the pre-hearing order came out this morning, I see that Mr. Harrison and Mr. Ives were switched. So Mr. Harrison's going first. If that was intentional as a preference of the commissioners, we'll leave it as is. If it was just an oversight, I would request that the order that I had requested with Mr. Ives, then Mr. Harrison be adopted.
Let me make sure that I understand what you're saying here, Belinda. The way our order has this, the order would be Harrison, Ives, and Vetch. Is that right?
Yes, that's what came out.
Whereas what you are requesting is what?
Was Mr. Ives, then Mr. Harrison, then Mr. Vetch.
And your reason for that?
Is that Mr. Ives is an in-house, he's an actual employee of the company in upper management, and he provides overview and can respond to questions specific about the company. Mr. Harrison he's an outside consultant, and he doesn't have that type of information or the authority to answer a lot of those questions. So we wanted Mr. Ives to address those first.
All right, I have no problem with that. So we will, when it comes to that time after the NextEra witnesses, the order of witnesses for Evergy will be Ives, Harrison, and Vetch.
Thank you.
Absolutely. All right. Are there any other preliminary matters? All right.
I'm sorry, Chairman Keene, but NETE Southwest does have one preliminary issue. Last night around 10 p.m. Central Time, there was an email request by council for the industrials to submit some kind of written opening statement that goes beyond the 15 minutes allotted to each party in this case. And NETE Southwest would object to that submittal. It's outside of the procedural order. It serves no purpose given the post-hearing briefs. We don't even know how to treat it. It's not evidence. It's just statements of counsel. And we would have no opportunity to respond to it. And so it would be prejudicial to NETE Southwest and the other parties.
Mr. Zakura.
Thank you very much. I was attempting to strike a compromise between what I think the commission wants, which is an abbreviated opening statement, and what I had hoped to do in terms of a greater framing of the issues of this case with a little more time. And so what I had suggested was that the opening statement that I had prepared, which would be in excess of 15 minutes, I think staff had asked for 30 at one point as well, that be submitted just as an opening statement. It is a statement of counsel. It's not evidence, but I think it does serve a purpose, which opening statements do, of framing the issue. Now, if the commission feels otherwise, certainly I would refer to that. But what I was trying to do was to strike a compromise between getting the hearing moving on an appropriate pace and also being able to frame the issues. So I'm certainly willing to abide by whatever the commission and thinks is best here. It was just a suggestion of compromise.
Mr. Schulte, and then I'll rule.
Every party has the same due process and procedural rights, regardless of the position that they're taking in this case. All the other parties are keeping their opening statements to 15 minutes. The pre-hearing officer during the pre-hearing conference suggested that there would be a limitation on opening statements, and we discussed different time, but 15 minutes was certainly our impression of the expected time to be allotted. And we prepared an opening statement to fit that time frame. Then at 10 p.m. last night, we were told that another party wants to submit some kind of additional information as an opening statement. It's outside of what all the other parties are expected and are abiding by, and it's prejudicial.
Okay, I'm going to rule on this. I believe, given the objection and in the fairness of all parties, we will still limit the opening statements to the time limits that we've indicated, that we've allocated to each of you. It is true that opening statements are not evidence. They are the statements basically of the case as each council sees it from their perspective. So I would encourage that to the extent that there are additional matters that go beyond the 15-minute requirement, Mr. Zakura, that if you would consider incorporating that within the post-hearing briefs, so that at least the commission will be aware of what your concerns were in that fashion.
Thank you very much. I will do so. Thank you.
Okay, are there any other preliminary matters? And I'm not going to spend much time asking or allowing that to happen. Okay, but this is fine. We need to work through these matters. I appreciate the indulgence of all parties toward that end. We're trying to provide due process in every way we possibly can. Let's turn now to procedures during the hearing. This hearing will address the non-unanimous settlement agreement, as well as NextEra's application for a certificate of convenience and necessity under KSA 66-131. Today is going to be a very full day. I'm pretty sure tomorrow is going to be one as well. It is our intention today to make it through all of through the examination of all of NextEra's witnesses. It is also the commission's intention to conclude this hearing as scheduled by the close of business tomorrow afternoon. You've been previously informed about the time that you have been allotted for the opening statements. For those who have been allotted 10 minutes and more, Assistant General Counsel Mr. Cohen will be timing your presentations and will hold up a card when you have roughly 1 minute of allotted time remaining, and another card when your time has expired. Please respect the process, the time constraints we're suffering under here, and stay within your allotted time. Let's now turn to the opening statements. So we'll begin first with NextEra and Mr. Schulte, please.
Thank you, Chairman Keene, and thank you, Commissioner French and Commissioner Duffy. We appreciate the work that the staff has put into this case, and we are pleased to be before you this morning to give you more information about NextEra Energy Transmission Southwest LLC, which we have been referring to and will continue to refer to as NETE Southwest, or the applicant. NETE Southwest is a wholly owned subsidiary of NextEra Energy Transmission, otherwise known as NETE, which is in turn a wholly owned subsidiary of NextEra Energy, Inc. NETE is a holding company for NextEra Energy's regulated transmission utilities across all of North America outside of Florida. NETE's portfolio includes operating assets in Kansas, Missouri, Oklahoma, Texas, Indiana, New Hampshire, New York, Nevada, and California. NextEra Energy, NETE's parent company, is the world's largest electric utility by market cap, with revenues in calendar year 2021 of approximately 17 billion and approximately 15,000 employees as of the end of 2021. NextEra Energy subsidiaries currently have approximately 11,800 circuit miles of transmission lines and 1,000 substations, which are located in every RTO and NERC region in the United States. The issue before the commission today is whether to grant NETE Southwest a certificate of convenience and necessity to construct, own, operate, and maintain 85 miles of 345 kilovolt transmission facilities in southeast Kansas. The 85 miles in Kansas are part of a 94-mile transmission line known as the Wolf Creek to Blackberry Transmission Project. The remaining 9 miles of the project will traverse north-south just east of the Kansas border and interconnect into the Blackberry substation, which is only a half mile from the Kansas border. The Blackberry substation is interconnected back into Kansas through the existing Neosho Blackberry 345 kV line that is owned by Evergy. The commission must determine whether NETE Southwest has the technical, managerial, and financial experience required to operate the project. Given the background of the company, which I just summarized, and the testimony that further explains the company's experience and background, NETE Southwest meets this standard by a wide margin. The commission must also determine whether the public convenience and necessity will be promoted by the project. In this context, the Kansas Supreme Court has clarified that public convenience means, I lost my place. It means the convenience of the public as a whole, not just the convenience of particular individuals. In addition, public necessity does not mean that there must be a showing of absolute need. Rather, as used, the word necessity means a public need without which the public is inconvenienced. The pre-filed testimony in this proceeding clearly establishes that the Wolf Creek to Blackberry project promotes the public convenience and necessity of Kansas. As NETE Southwest witness Becky Walding testifies, this project relieves significant congestion in southeast Kansas, which is presently causing high locational wholesale power prices, and at times causing the curtailment of the Wolf Creek nuclear generator. The project is a major component of the portfolio recommended by the Southwest Power Pool in its 2019 Integrated Transmission Planning Report. You will hear that report referred to as the ITP report. The Wolf Creek to Blackberry line constitutes more than half of the mileage of new high voltage transmission included in that portfolio. The ITP report is included in the record of this case as an exhibit to the direct testimony of Becky Walding. Studying transmission projects as portfolio is the integrated part of integrated transmission planning. Not only would it be inefficient for SPP to conduct a project by project study, it would be illogical. Transmission projects are not built in isolation. If one were to study the impact of a single transmission project in isolation, the results would be unreliable, as it would be the study of a future that will never come to pass. Studying transmission portfolios on a regional basis is also extremely beneficial to Kansas. Just over a year ago, the benefits of regional planning were evident when the SPP grid performed admirably during Winter Storm Uri, keeping the lights on for its customers with minimal disruption. As SPP's witness, Kelsey Allen testifies, SPP determines comprehensive regional solutions to address reliability and economic needs. And SPP implements the best long-term solutions, providing both immediate and long-term benefits. Staff witness Justin Grady testified that Kansas cannot separate itself from the rest of the SPP footprint and ensure the reliability of its electric grid or the competitiveness of its wholesale energy markets. Accordingly, there can be no doubt that that Kansas's participation in SPP is a huge net benefit to the state. But even if we set aside the broader view of these SPP benefits and narrow our focus to the Wolf Creek to Blackberry project alone, it remains evident that granting a certificate to NETE Southwest is in the public interest. SPP found that the new Wolf Creek to Blackberry transmission line is cost beneficial as a standalone project in the 2019 ITP. It also found the new Wolf Creek to Blackberry line provides multiple reliability benefits. Primarily, it resolves declining transient stability margins at the Wolf Creek nuclear plant by adding a fourth 345 kV outlet that is expected to increase system resiliency and reduce system operation risks. As discussed in Ms. Walding's testimony, the 2019 ITP portfolio is anticipated to save customers 9 cents per kilowatt hour. Further, the 9 cents per kilowatt hour is based upon SPP's estimated cost of the project, which was $142.6 million, compared to NETE Southwest's estimate of $85.2 million with cost caps. Accordingly, the savings to Kansas customers could be even greater. There are also local economic benefits generated by the line, as testified by NETE Southwest witness David Loomis. The project is expected to generate nearly 1,000 jobs during construction and 6 to 10 long-term jobs during operation. Additionally, the project is expected to generate $145 million in economic output during construction and approximately $5 million per year in economic output during operation. For these reasons, the original application as filed clearly promotes the public convenience and necessity. The settlement agreement in this case, which is supported or not opposed by 9 of the 11 participants in this proceeding, further enhances the benefits of the project by establishing certain conditions. These conditions include a requirement that NETE Southwest include its cost containment measures in its FERC formula rate filing, a 40-year commitment from NETE Southwest parent company to provide up to $10 million a year in equity capital injections as needed to maintain the financial integrity of the project, a requirement that NETE Southwest cooperate with Evergy on issues of interconnection, project management, impact on the existing system, transmission planning, and future interconnections. A requirement that NETE Southwest provide information on line galloping and mitigate any line galloping issues. A requirement that NETE Southwest maintain sufficient personnel in the region so it can respond to emergencies in a timely and effective manner. A requirement for detailed quarterly reports during construction. A requirement that NETE Southwest file numerous documents with the commission upon completion of construction, including an emergency response plan, a communications plan, and an emergency response contracts. And a requirement that NETE Southwest make annual reports to the commission on issues like outages, maintenance activities, inspections, and emergency response contacts. Accordingly, what was already a very robust application has been enhanced even further due to the conditions established in the settlement agreement. The settlement agreement meets the standards for commission approval of non-unanimous settlement agreements. First, there was an opportunity to be heard for the parties opposed to the settlement agreement. The opposing parties were provided the same notices of deadlines in this case, with the same opportunity to issue data requests, the same opportunity to submit pre-filed testimony, and are subject to the same rules of evidence and procedure as all of the parties in this case. Second, the settlement agreement is supported by substantial competent evidence. As I have discussed, the parties have filed extensive evidence in this case supporting the public convenience and necessity of the project and the qualifications of NETE Southwest. Third, the settlement agreement comports with applicable law. The commission is authorized to approve the settlement by the Kansas Administrative Procedure Act and pursuant to KAR 82-1-230A. The terms of the settlement agreement retain the commission's continuing jurisdiction and oversight over NETE Southwest and the project. Fourth, the settlement agreement results in just and reasonable rates. NETE Southwest's cost for the project will be recovered through its FERC-approved formula rate and associated customer review and challenge protocols. And the prudence of NETE Southwest project expenditures and applicability of NEAT Southwest cost containment commitments will all be subject to review and oversight by FERC. Finally, the settlement agreement is in the public interest because it provides for the construction, operation, and maintenance of a transmission project that will lower rates for Kansas customers and improve the reliability and resiliency of the transmission grid in Kansas. As the commission is aware, there are two parties opposed to the settlement agreement. The two parties opposed base their opposition on issues outside the scope of this proceeding. The industrial customers take issue with cost allocation policies that are governed by FERC and are outside the jurisdiction of this commission and the scope of this proceeding. Further, the industrial's proposed relief in this case, which is denial of the certificate, would not resolve any of the issues that they raise. In fact, the industrial's witness, Dr. Macholm, refers to NEAT Southwest as a, quote, beneficial competitive electricity transmission entrant, but then suggests that this beneficial entrant be denied a certificate to do business. Dr. Macholm also laments the difficulties that Kansas faces trying to move abundant wind from western parts of the state to load centers, but then recommends the denial of a transmission project that is intended in part to help with that issue. Dr. Macholm also has no basis for his assumption that the project will increase rates for Kansas customers. And in fact, as I previously discussed, that assumption is directly refuted by evidence to the contrary in this case. The other party opposed to the settlement are two landowners, Darren McGee and Rochelle McGee Smart, who own property along the project's potential route. Their primary issue appears to arise from a misunderstanding regarding the purpose of NEAT Southwest's field activities in preparation for its line siting application. As discussed in Ms. Walding's pre-filed testimony, and as NEAT Southwest does not contest, NEAT Southwest is conducting preliminary survey work with the permission of landowners along the potential route. The McGees seem to imply that these surveys qualify as NEAT Southwest beginning construction of the project. But as the commission is well aware, survey work conducted with the permissions of landowners does not require a CCN. And it is a necessary step to develop a routing study to be used in the siting proceeding that will follow this proceeding. However, to be perfectly clear, NEAT Southwest is not accessing property unless and until it obtains landowner permission, and it is not otherwise conducting business in the state that requires a certificate. Additionally, the commission is well aware that the McGee's siting concerns will be the subject of a separate proceeding following this one that will address the reasonableness of the route of the line. The commission should not give weight to the red herrings and extra jurisdictional issues raised by the industrials and the McGees. Instead, we respectfully request that the commission find that the Wolf Creek to Blackberry project is in the public interest and issue a certificate of convenience and necessity subject to the terms of the settlement agreement so that NEAT Southwest may construct, own, operate, and maintain this critically important and beneficial infrastructure project. Thank you.
Thank you, Mr. Schulte. We're grateful for your adherence to our time constraints as well. The next opening statement will be for Evergy, Glenda Kafer.
Thank you, commissioners. Good morning. Evergy had concerns when it was coming into this docket as an intervener. An overarching one was the problem related to the lack of transparency, allowing parties that had an interest here the ability to do an adequate review and analysis of the positions they might want to take. As an owner of Wolf Creek, Evergy also had concerns related to the line's proximity to the nuclear power plant, the interconnection at the Wolf Creek substation, and the line's potential impact on Wolf Creek's operations and reliability. Evergy was unsure about the financial abilities of the soon-to-be certificated entity NEAT Southwest to safely and reliably operate and maintain the line after it went into operation as a standalone company. And a major concern that Evergy had centered on the potential for cost overruns. And there was a major disparity between the other bids on the project and NETE Southwest, and equally a large disparity between NETE's bid and the SPP estimate. And so there were questions about what type of risk was being run, who would pay if there were some cost overruns, would that have some impact on reliability and safety due to the need to cut corners or save on expenses. And along the same lines, Evergy believed that some reporting needed to be done during the construction, not just after the line became operational. NETE Southwest worked with us on our concerns, and it resulted in the settlement that we've submitted to you for your consideration. They compromised first and importantly by designating or redesignating some information as just confidential instead of confidential competitive. It was information then that some of our in-house people could look at so they could make an informed decision as to what a good settlement needed to have as its terms, and then become a part of that settlement when it was included. They also made major commitments regarding future rate filings and their affiliate pricing standards and the reporting requirements and their affiliates' financial obligation to support the company. And very important to Evergy, they agreed to locate their interconnect outside of the Wolf Creek owner-controlled area and to work collaboratively with us on engineering standards that we believe are imperative for the facilities that are located near the Wolf Creek plant. So what's never been in question here is Evergy's belief that this project is necessary. And it is necessary to address the congestion, the safety, reliability issues on the transmission network in Kansas. It will benefit the operation of Wolf Creek, and it will benefit our customers. And with the additional conditions contained in the SNA, Evergy supports the commission granting NextEra's application for a certificate to do this project. Thank you.
Thank you, Ms. Kafer. Next opening statement will be for KIC, Jim Zakura.
Thank you, commissioners. I want to say in response to a couple of things that Mr. Schulte said, that I believe it's important that we are in this case. We are presenting a point of view that we believe is a legitimate point of view, which the commission can consider among all of the issues that they'll consider in this case. I think it's particularly important because when you have a settlement agreement, it tends to be like an echo chamber of everybody agreeing that it's the right thing. And at the end of the day, the commission still has to make a decision whether or not it's in compliance with Kansas law. And what we do and what we hope to do here is to sharply draw those issues for you, and that you can then make the decision as you feel is appropriate in the best interest of the state of Kansas. So we're proud to be here. We're not at all put back by being in opposition. We think it's important because we think we have important considerations to make. I am representing a group of retail ratepayers. They basically fall into two groups. Number one, the retail ratepayers that are served by Evergy Kansas Central, and a large group of ratepayers that are served by distribution electric cooperatives that are served by Sunflower Electric Power Corporation. We consider this case to be the most important case to come before the commission in 10 years. And let me tell you why. Number one, the commission needs to determine what's the boundary between state law and regional planning, what it means when you have to make a decision in Kansas as to the necessity of a project. The second, and equally and maybe more important, is we have a good problem in Kansas, and that is we have far more electric generation than we consume within the state. And in 2018, that excess production was 19% of all of the electric energy produced in the state. And in 2020, which is the latest from the Energy Administration, U.S. Energy Information Administration, that has already grown to 26%. Now, that is the wonderful blessing and the challenge of having wind additions in our state. We have all of this additional wind capacity coming on to the state. which needs a home outside of our state because we're not consuming it. And we need the commission to address this and to be able to provide leadership as to how we can put buyers and sellers of that together and come into balance in our state. We feel strongly that retail ratepayers don't have a responsibility for transmission of electric energy that goes outside the state of Kansas, and particularly outside of SPP. So those are two really important issues that are before the commission. And we're grateful to be here, and we think this is a truly important case. Turning to the particular case, first of all, the commission, as you know, must decide this case under Kansas law. KSA 66-131 mandates that before the commission can order a certificate, the commission must first find that the public convenience and necessity will be promoted by the transaction. In this case, the construction of 85-mile, 345 kV line by NextEra. The word necessity, as used in the public statute in Kansas, is without which the public is inconvenienced to the extent of being handicapped. I will note that I believe all the parties are going to come together on what the legal standards are. I don't think at the end of this hearing there'll be a dispute as to the facts. The issue will be how the commission applies those facts to Kansas law. I think it's going to be a clear-cut, sharper kind of decision for the commission to make. In our view, the NextEra application cannot be approved by the commission for several reasons. Number one, there's no public need in Kansas for the Blackberry line. The need in Kansas for the Blackberry line is being served by three already existing 345 kV transmission lines that provide power and have done so for Wolf Creek since 1985. Second, there's no evidence in the record as to Kansas specific costs and benefits of the Blackberry line. This is particularly important because if you trace the necessity statute in Kansas to the creation of the SPP came into existence in 2004, and the provision for the necessity came into existence, Kansas law, in 2005. In 2006, the legislature rejected further regionalization of Kansas planning of electric transmission in the state. So we have our original statute, and that statute requires that there be a necessity and that the commission find a necessity for the project. And there's no evidence in the record as to Kansas specific necessity. As pointed out by curb witness Franz, because SPP's transmission planning process is regionally focused rather than locally focused, benefits and costs to the Wolf Creek Blackberry project have been quantified by the SPP at the regional level. Neither SPP nor NETE Southwest have quantified the Kansas specific benefits. Further noted, one further thing, if I could, on that point, SPP expressed concern over the practicality and accuracy if it were attempt to do Kansas specific findings. So there's no dispute in the record. There's no Kansas findings of necessity in the record. Dr. Malcolm further spoke to that point by stating, at a minimum, the KCC must have the facts regarding Kansas specific impacts. Instead, the KCC is being asked to approve Blackberry based on overall SPP metrics, not Kansas impacts in a situation where Kansas metrics may well differ. He goes on to state, I note in support of my point that in addition to the staff, Ms. Walding's testimony only refers to SPP benefits and costs and not to Kansas benefits and costs. And to speak to a further point mentioned by counsel for NextEra, there's 44 projects in the ITP program, and there's no particular Kansas benefit and cited, and there's no particular benefits other than the 44 case benefits cited by SPP. So we also have a concern that this will increase the prices in the state of Kansas. And at this point, we do have a difference of opinion between the staff and the applicant. We think it's very clear that this process is designed to, as SPP says, levelize the cost of electric energy across the region. And what that means in layman's terms is that the low costs that are enjoyed by Western Kansas will be increased so that the higher costs in principally Missouri and eastern Oklahoma will be decreased. So levelizing means increased costs in the state of Kansas. That's particularly troublesome because entities like Sunflower Electric Power Corporation have spent millions and millions of dollars on transmission and have benefited from lower energy costs, in part because in their case, there's 3 times the energy attached to their system than they have demand. The same would be true for Midwest Energy as well. Now, this gets us to the point and why we have asked Mr. Macomb to be here. We need a plan in Kansas. We need a way to deal with all this excess energy. And as stated by the editors in the February 22 issue of Public Utilities Fortnightly, Kansas is grappling with a multitude of issues, including moving that wind to faraway places that want it. As further noted in that article by Commissioner French, the biggest nut to crack is how do you get the energy to faraway load centers? I would note to the Commission that this issue reached a boiling point in 2017, and that is when the legislature commissioned the 2017 rate study. One of the highlights of that was the basically complaints registered by many of the Western Kansas utilities that SPP was asking them to do something that their systems were never designed. And if I could quote from the study just for a moment. One stakeholder pointed the project team towards SPP's 2017 strategic plan documentation, in which they stated this method does not and was not intended to fairly recover the cost of transmission built and used solely to export renewable resources to markets outside of SPP. Stakeholders recommended that transmission costs instead be fairly allocated between those who sell and use the exported energy, such as through the creation of a unique export pricing mechanism. Now, I want to make this really clear. The retail ratepayer group absolutely supports the addition of wind and other renewable resources to the SPP managed electric grid. However, the addition of renewable resources to the grid must include a reasonable allocation of costs among those that benefit from these wind additions. In our view, it's not an appropriate cost assignment to charge retail ratepayers for the export and transmission costs of excess energy in the state of Kansas. It is not efficient and sufficient service provided to those consumers. It is in excess of the amount of electric energy that they use. Now, to reiterate, and what I hope will be lots of questions from the commissioners for the witnesses, and particularly Dr. Macomb, we need a plan in Kansas. Kansas has no plan to develop its abundant wind resources and export those wind resources in a manner that does not further burden Kansas retail electric ratepayers. The failure to date of the legislature working with the KCC to address and come to grips with this dual issue of the development of the abundant Kansas wind resource and the export of that resource without burdening Kansas retail ratepayers is why KIC is sponsoring the testimony of Dr. Jeff T. Macomb. I would say one thing that I think will bring some further clarity to this issue. For a correct understanding of this case, the most important issue, you must follow the net energy transfer. You cannot change or alter the laws of physics. This case is a case of first impression, where the retail ratepayers of Kansas and those throughout the Southwest Power Pool are being asked to 100% finance a project designed to export power outside of Kansas and outside the Southwest Power Pool. This export project is from Kansas and the SPP to Associated Electric in Jasper County. Based on our research, no one in Kansas or anywhere has ever been asked to do this by a regional transmission organization until the Sprattberry line case. To sharpen this issue, both the Mid-Continent Independent System Operator, MISO, and AECI both said there was no economic benefit to them of the Blackberry line, and they've refused to help pay for it. it's paid 100% by the retail ratepayers ultimately who reside in the SPP region. In addition, the commission must decide, because the Blackberry is a bi-state project in Missouri, if it is a necessity under Kansas law for Kansas electric ratepayers to be charged the electric transmission line and substation construction in Missouri outside the SPP footprint. To conclude, the overarching most important public policy issue in Kansas in the energy area is to develop a well-reasoned, efficient plan of action to export the abundant Kansas renewable resources to demand centers in other states. States that want Kansas wind energy and are willing to pay for transmission to obtain this Kansas clean energy resource. The Blackberry line does not do this or even address the Kansas policy imperative. It provides no demonstrable benefits to Kansas consumers, and no one has even suggested that it addresses in any manner the Kansas policy imperative to reasonably export its excess energy. It simply piles more costs on Kansas consumers and pushes energy costs higher in much of the state of Kansas. It is truly a lose-lose project. The testimony of Dr. Macomb addresses this Kansas public policy imperative. He presents a proven path forward for the export of the abundant Kansas wind resource. The path is Kansas-centered and is not a burden of Kansas retail ratepayers. In conclusion, was that the 1 minute or the conclusion, David? In conclusion, I would say that this is, to us, the most important case that's come to the commission in 10 years. It is a case study of what is the comparative rights of Kansas necessity compared to regional planning. And more importantly yet, it is the first time that we have had a chance at the commission to really address this critically important issue of how do we handle this ever-growing, increasing amount of electric energy that is in excess of what Kansas consumers use. We must deal with that, but that's a double-edged sword. If we deal with that correctly, Kansas can be a great leader in helping the nation and the region with clean energy resources and to work on having less carbon throughout the US. Thank you.
Thank you, Mr. Zakura. The next opening statement will be for the Southwest Power Pool. Heather Starnes. Ms. Starnes, please.
Good morning, Your Honor. Chairman Keene, Commissioners Duffy and French, may it please the commission. My name is Heather Starnes. I'm here on behalf of Southwest Power Pool. We are the RTO, or the Regional Transmission Organization, that operates in 14 states, including Kansas. We've been around in some form or fashion since 1941, but have also been a regional transmission organization since 2004. I'm not going to argue through all of Mr. Zakura's points. I just want to make sure everybody has sufficient background on what SPP does and what it doesn't do. This particular case focuses on SPP's role as the regional transmission planner for the members and customers that are a part of its regional transmission organization. These include 107 members, including utilities in Kansas. We are FERC approved. We have a FERC approved tariff that specifies our planning process, which is a regionally focused planning process. SPP's role is to develop solutions for economic reliability and public policy needs that address these needs on a regionally focused basis, rather than a smaller individual state by state or utility by utility basis. So I want to kind of give that preface up front. When we conduct our planning process, which is called the Integrated Transmission Plan, it's in Attachment O of the SPP tariff, we look at a portfolio of projects that in the most economic and regionally based cost-effective plan addresses all of the needs that have been presented in the transmission planning process. This planning process is very extensive. It's very transparent. it goes through an entire stakeholder process of multiple stakeholder groups, including the Regional State Committee and the Cost Allocation Working Group, which include state commissioners and members of their staffs. Everyone is allowed to take part in this process. They are public meetings. Anyone can ask questions or seek information. And the result is that we present to the stakeholders, the members, our board of directors, as well as the Regional State Committee, a portfolio, a plan that is to help make sure that we can provide cost-effective deliveries of power and meet the reliability needs of our members and customers. This project, this is the subject or is part of this application, came out of the 2019 Integrated Transmission Plan. That report has been submitted as a part of our witnesses' testimony and provides a lot of very descriptive and valuable information about both the reliability and the economic needs served by this project. And our witness, Mr. Allen, certainly details that as well. It's difficult for SPP as a regional transmission planner to be able to take a portfolio of projects that addresses all of the needs that have been determined that need to be addressed, develop those solutions, and then somehow divide those benefits up by state and by utility. We attempt to do that in some fashion, but that really goes against the way we plan, which is for the region as a whole. While I certainly don't disagree with Mr. Zakura that Kansas is very obviously a wind-rich state and that there is a lot of wind that is being developed and will be developed for export, I think the point that's important to note here is that developing solely Kansas solutions is virtually impossible when you have wind that's going to be going to other states and other regions. That just reinforces the need for a regional plan. Facilities will be used to export wind and to provide wind to its own customers and all sorts of energy besides just wind, solar, and other. But more importantly, if this renewable energy is to be exported, it is going to be used, it is going to travel on other facilities in the SPP system. It is not just going to be, here's this great wind in Kansas, we're going to export it somewhere else. You will be using others' facilities. And therefore, it is imperative that you work in a regional fashion to make sure we can resolve any issues that are created by the development of more wind resources. And that's exactly what SPP does in its planning process. The difficulty lies, and I understand Mr. Zakura's explanation with this respect, is trying to identify that all the way down to what are the specific benefits for specific Kansas ratepayers. That is not SPP's role. SPP's role is to ensure cost-effective solutions that provide for the resources that are online or are coming online to serve the customers that need to be served. And we look at it in an overarching fashion. Even the staff in its testimony has acknowledged that Kansas can't deal with its energy situation, its transmission solutions. They can't do these alone. And that there is value to Kansas in participating in SPP and the regional transmission process. Now, we are here to answer questions with respect to that process, and we are here to support the project as presented in that it is necessary. It serves both economic and reliability needs. And through SPP's tariff-approved processes, NextEra Southwest was determined to be the entity who would construct that project. We support the settlement that has been proposed, as we feel it addresses all of the issues of most of the parties, with the exception of Mr. Zakura and the landowners, and ensures that the commission can find that not only is this project necessary, but that NETE Southwest should have a CCN to construct, own, and operate that facility. We are at the commission's disposal to provide any information that they believe is helpful. And we will certainly work with Kansas in any way that we possibly can to ensure that the future of Kansas and all other states in SPP are allowed to fully develop their renewable resources to the benefit of their state, but also to the benefit of all the region as a whole. We appreciate your consideration this morning, and we're happy to be here.
Thank you, Ms. Stearns. The next opening statement will be on behalf of Darren McGee and Rochelle McGee Smart and presented by their counsel, Rustin Kimmel. Mr. Kimmel, please.
Thank you, Commissioner, and good morning again. As you mentioned, I represent Darren McGee and his daughter Rochelle. The McGees own and operate a row crop and cattle farm in Anderson, Allen, and Coffee County, Kansas. As Mr. Sakura just discussed with you, there is no evidence that this transmission line provides a net benefit to Kansas. The proposed line does not benefit the companies that employ the state's workers and is no help to those citizens themselves. It simply raises their costs. I won't replow Mr. Zakura's tilled ground, but just say that the state legislature charged the commission with protecting the interests of Kansas, not to blindly follow the dictates or desires of the Arkansas-based Southwest Power Pool. The commission can protect the interests of Kansas by firmly and strictly enforcing Kansas law and the statutory limits that the state legislature has imposed on companies that want to work as utilities in this state. For instance, KSA 66-131A prohibits any company subject to the commission's authority from conducting business in this state before the commission issues a certificate of convenience and necessity. Counsel in his opening statements seem to suggest that NextEra can ignore that legislative mandate if it wants to enter into agreements with landowners. It's simply not the plain language of the statute. The evidence shows that NETE Southwest has ignored that legislative prohibition and has systematically engaged in business without a certificate by attempting to bully landowners into executing easement agreements under threats of eminent domain. Similarly, KSA 66-1178A prohibits any company from beginning site preparation for an electric transmission line until the commission issues a siting permit. The evidence shows that NETE Southwest has ignored this legislative prohibition too. NETE Southwest has systematically entered into landowner property without landowner permission to survey, collect soil samples, conduct geotechnical tests, or conduct environmental, biological, and cultural studies. NETE Southwest has done all this work in preparation for constructing this proposed Wolf Creek to Blackberry electric transmission line, and it did it all without the commission issuing a siting permit. NETE Southwest's habitual disregard for Kansas law demonstrates that it does not have the managerial capabilities necessary to conduct business as a public utility in the state. NETE Southwest disregard for Kansas law, its property owners, and the unfair cost Kansas will pay due to the proposed Wolf Creek Blackberry transmission line is too much. At the close of this hearing and in a subsequent briefing, the McGees will ask the commission to deny NETE Southwest application for certificate of convenience and necessity. Instead, they will ask the commission to fulfill its legislative mandate to protect the good citizens of Kansas from NETE Southwest predatory practices and protect us all from an ill-conceived project that will only increase costs on the citizens and businesses of this state. Thank you.
Thank you, Mr. Kimmel. The next opening statement will be for the Citizens Utility Ratepayer Board. Joe Astrom, please.
Thank you, Commissioner. May it please the commission. My name is Joseph Astrab, and I, along with attorney Todd Love and consumer counsel David Nickel, represent the Citizens Utility Ratepayer Board, or CURB, Today, CURB is before the Commission in support of the non-unanimous settlement agreement filed in this docket regarding NETE Southwest's application for a certificate of convenience and necessity in order to comply with the notice to construct for a new transmission line on behalf of the Southwest Power Pool, or SPP. CURB support for the agreement is sponsored by Senior Rate Analyst Josh Franz. He testifies that the settlement agreement meets the criteria used by the Commission to approve non-unanimous settlement agreements. Mr. Franz describes CURB's statutory authority and role before.
Mr. Astrop, could you please slow down a little bit?
I apologize. Yes, of course. Mr. Franz describes CURB's statutory authority and role before the Commission as it relates to the Southwest Power Pool and this particular application. One of CURB's missions is to advocate for fair and reasonable rates and charges for the provision of efficient and sufficient service. Mr. Franz further explains the KCC's history with SPP and the recent dockets that explored the value that SPP provides Kansas. CURB recognizes from those dockets that the KCC acknowledges that SPP membership is providing a benefit overall to Kansas ratepayers, but that the KCC also holds value in having data specific to Kansas metrics. The parties opposed to approval of the certificate view the application from different perspectives. The landowners have expressed concerns with impacts on Kansas system reliabilities for farmers and the unlawful use of eminent domain to facilitate these projects. Meanwhile, KIC and its affiliates, who are large industrial consumers of electricity, wish to deny the application as a means for Kansas to shift away from the SPP's region-centric planning process in order to promote long-distance transmission lines to sell renewable energy for the benefit of other businesses and customers outside of Kansas through the use of collaborative multiple states powers of eminent domain themselves. CURB further believes that the KCC performs a vital role in representing Kansas' interests at the SPP and at the federal level. The KCC has developed a long-standing relationship with SPP through participation in various committees and decision-making bodies as allowed by statute. Through that outreach, KCC works to provide information and to explore the benefits of a regionally coordinated transmission system. One important takeaway from this participation is the fact that all members contribute to the continuation of that system. Everyone pays a cost to be a part of that system. It's like being a member of any other kind of club or cooperative group that shares resources and efforts by its members. One such aspect of the SPP used by Kansas is integrated marketplace, as discussed by staff witness Justin Grady, where Kansas sells and buys energy to meet its demand. Sometimes that membership pays off, and sometimes it seems like it's more of a hassle than it's worth. I don't mean to dramatize the topic of utility regulation, but it is this simple notion that being a part of a larger organization has its ups and downs that leads CURB to lend its support to the agreement. The SPP has conducted a rigorous and competitive bidding process that has been approved by FERC. That process led SPP to select the project proposed by NextEra, which has led us to this application for a CCN. The signatories reached an agreement with NextEra to approve the application and to impose detailed reporting and performance requirements. Parties in this docket have performed a review of the SPP process and NextEra's capabilities to fulfill the requirements to construct the project and determine that the application should be approved and that the projected costs for ratepayers are low enough to warrant contributing to the regional transmission system overall. Through arguments and briefing, the parties will walk through the appropriate interpretations of Kansas statutes and realities of the project and SPP's role in the regional transmission system. CURB is assured that the KCC and interested parties will continue exploring the measurement of Kansas benefits beyond this docket, and CURB remains committed to assisting the KCC in those duties and representing the interest of all Kansas residential and small commercial ratepayers. Thank you.
Thank you, Mr. Astrop. All right. The final presenter for the opening statements is on behalf of the KCC staff, Jared Jevons. Jared, please.
Good morning, Commissioners. The matter before the Commission today is to determine whether a certificate should be issued to NETE Southwest to operate as a transmission-only public utility in Kansas. To be clear, this is not a line citing docket. In the event the commission grants NETE Southwest a certificate at the conclusion of this docket, the specific siting for the project will be determined when NETE Southwest files a line siting application. So here, the issue is whether NETE Southwest should be granted a certificate if it can demonstrate a need for the project, and if NETE Southwest has demonstrated itself capable of operating a transmission line in Kansas. For more than a decade, the commission has reviewed certifications like this one. Throughout those dockets, the commission has concluded that the granting of a certificate must promote the public interest, and the applicant must demonstrate the financial, managerial, and technical capability to operate as a utility in an efficient and sufficient fashion. While the Blackberry project is new and NETE Southwest hasn't previously been certificated as a public utility in the state of Kansas, the questions and issues before the commission are not unique. Standards exist, and those standards have been applied repeatedly and consistently over decades by the commission and its staff in issuing orders. Staff applied those standards in this docket as it thoroughly reviewed NETE Southwest's application. After this in-depth process in which staff applied voluminous evidence to the standards, staff concludes the project is needed and will benefit Kansans. Staff also concludes NETE Southwest possesses the necessary technical, operational, and managerial expertise, as well as the financial capabilities necessary to construct, own, operate, and maintain the project. To understand why staff's conclusions matter, it is helpful to put staff's role in contrast to the other parties in the docket. There are multiple interests represented by 11 parties in this docket. Because there are 11 parties in this docket, I will not describe all of them, but to describe a few, NETE Southwest's interest is getting the line built without conditions so onerous as to diminish its ability to complete the line on time and under budget. The utilities represent the interests of their management and shareholders. The landowners represent their personal interests, and the Kansas Industrial Consumer Group represents the interests of several large Kansas industrial power users, as well as some retail ratepayer interests that have consolidated with the KIC group. CURB represents the interests of residential and small commercial ratepayers. Notably, CURB is a signatory to the settlement. Finally, staff represents the interests of the public generally by balancing each of the above named interests. Staff is also a signatory to the settlement agreement because on balance, the settlement promotes the public convenience and necessity, and NETE Southwest has demonstrated it has financial, managerial, and technical capabilities to operate as a utility in the state of Kansas. There are multiple issues in this docket, which include the need for and the benefits of the project, and whether NETE Southwest is capable of operating as a public utility. But perhaps the issue of need hasn't been set forth in plain terms. Up to this point, I've stated staff's belief that the project is needed, but not why. So I'd like to describe why the project is needed. The project addresses multiple reliability and economic needs. First, it increases transmission capability and resiliency within Kansas. And two, it addresses specific local reliability needs near the Wolf Creek nuclear generating station. One of the keys to understanding why this project is beneficial is understanding that wholesale electricity prices are affected by congestion on the transmission grid, and therefore, oftentimes, retail electricity prices are also affected by grid congestion. Congestion exists in the specific locations on the grid because of physical attributes of the grid in a particular location. One of the places where transmission congestion exists is near Kansas's Wolf Creek nuclear generating facility. I'm sharing the screen with you now. This graphic illustrates the congestion that exists in southeastern Kansas. This is an image created by Southwest Power Pool and is included in Justin Grady's testimony in support of the settlement agreement. On top of the image, I've indicated the location of Wolf Creek. What you see in this image is a side-by-side image of the Midwest from North Texas to North Dakota. Overlaid on top is a heat map representing the wholesale price of electricity. Cooler colors indicate lower prices, warmer colors indicate higher prices. The image on the left is prices in SPP without the project. The image on the right is an image of SPP with the project. Wolf Creek is depicted on the map in southeastern Kansas in the yellow-green shading. The project will run from Wolf Creek through yellow-green shading into Missouri. The yellow-green shading in southeastern Kansas represents the increased wholesale prices for energy due to congestion. Congestion in this location increases the price of wholesale energy in southeastern Kansas to the detriment of customers in southeastern Kansas, and many of whom are Evergy customers. The right image depicts a wholesale price of energy in the region after construction of Blackberry. The congestion in southeastern Kansas is reduced, and so are the wholesale prices. This project, while addressing congestion in the vicinity of Wolf Creek, also addresses multiple reliability issues. These reliability issues are complex, but are important to understanding the need. Wolf Creek currently has three 345 kV transmission lines or outlets attached to the substation near the nuclear plant. This project has a fourth 345 kV outlet, which increases system resiliency and reduces system operational risks. So how does the project increase system resiliency at Wolf Creek? Wolf Creek is required to derate in certain circumstances, like when one of the other lines is out for maintenance, or a storm has impacted its operations, or any one of the current 345 kV outlets is unavailable, or if there's an excessive transmission congestion in the vicinity of Wolf Creek. That congestion frequently occurs in three locations: the 138 kV Butler-Altoona line, the 161 kV Neosho Riverton line, and the Wolf Creek transformer, which supplies network loads between Wolf Creek and Neosho. Adding the fourth 345 kV line at the Wolf Creek substation relieves the congestion in these locations, thereby enhancing system reliability. To reiterate, this line doesn't take away from the reliability of Wolf Creek or diminish its ability to serve Kansans, as has been misrepresented in the Docket and by some in the media. This line will improve the reliability and operation of Wolf Creek to the benefit of Kansans by reducing local Kansas congestion. So how does the project reduce system operational risks? First, a fourth line is a permanent solution to current and projected power flow and stability issues near Wolf Creek. Second, a fourth line means Wolf Creek will no longer need to power down during planned and unplanned transmission outages around Wolf Creek. Third, when planned and unplanned outages occur around Wolf Creek, there will be another source of offsite power to Wolf Creek. Fourth, transmission line maintenance on the three existing 345 kV lines is limited to Wolf Creek refueling outages. The fourth line will permit maintenance on the existing 345 kV lines at times other than during refueling outages. Now, those are a bunch of technical reasons for why the project is complete, but the benefits do not stop there. In fact, Southwest Power Pool's 2019 Integrated Transmission Plan shows customers in the former KCP&L region receiving a net rate benefit of between 19 to 44 cents per month from SPP's planned projects. Customers in the Westar region will receive a net rate benefit of 30 cents to 37 cents per month from SPP's planned projects. Same information is available for the entire state of Kansas in the 2019 ITP. SPP projects net rate benefits for the state of Kansas of between 7 cents to 9 cents per customer per month after all costs are paid for. It should also be noted that these benefit tests all used the originally estimated cost of the Wolf Creek to Blackberry line, which was approximately 60% more than NextEra eventually agreed to build it for, meaning that the benefits here are conservatively estimated and likely understated. However, benefits will not only occur on the day-to-day use of the Blackberry line. Benefits will also exist in unplanned situations. For example, if another Winter Storm Uri-like event occurs, the Kansans and SPP will have an additional link to power from the east. To be sure, this project costs money. NETE Southwest estimates the impact of the project on the average customer bill will be 4 cents per month. Staff's independent calculations come up with the same result. But this doesn't account for the SPP modeling I just discussed that shows a net rate benefit for former KCP&L and Westar customers and Kansas as a whole. Taking these benefits into account, Kansas customers will likely save money on a monthly basis over the life of the project. Now, if you recall the statutory standards that have been explained by other parties in this docket, the statutory standard to be applied is the public convenience and necessity. Public convenience means the convenience of the public, not of any particular individual or individuals. Public convenience and necessity is established by proof of conditions existing in the territory to be served. Now, I just described the conditions existing in Kansas that will be served by the project. The project improves the reliability and resiliency of Kansas's electrical grid, reduces congestion, provides protections and operational flexibility of Wolf Creek's nuclear facilities, provides a backup source of power in extreme weather events, and is projected to reduce overall rates. All of that leads staff to conclude that the project serves the public convenience and necessity. Therefore, the project is needed. I'd also like to address several misunderstandings and misstatements that have entered the public record since NETE Southwest application was filed February 28th. These misunderstandings and misstatements relate to the project's cost allocation, the Commission's rate setting authority, and staff's independent analysis. With respect to the cost of the project, clarity on the project's cost allocation needs to be provided. The cost of the project is subject to region-wide cost allocation. In this docket, when you hear the term region-wide, it most often means the 14-state region of the Southwest Power Pool. Region-wide cost allocation allows the costs of some transmission projects to be spread equally across all 14 states in the Southwest Power Pool. Because this project is for a line rated over 300 kilovolts, cost of the project is spread equally across the entire region. In other words, Kansas customers do not pay for 100% of the project. Looking at the entire state of Kansas, Kansas will pay for approximately 16.5% of this line. With respect to the Commission's rate setting authority over this project, the project is an interstate transmission project, which means FERC has exclusive jurisdiction over the rates. In this case, SPP administers NETE Southwest transmission formula rate, which is exclusively regulated by FERC. And NETE Southwest transmission formula rate has already been approved by FERC. This does not mean that the Commission or any other party cannot challenge the transmission formula rate. It simply means that this is not the form in which to challenge the rate. If at any time the Commission found reason to do so, the Commission could challenge this rate at FERC. While the rates resulting from the project are not within the Commission's authority, many other issues remain within the Commission's purview. The Commission has the authority to determine whether there is a Kansas-specific NETE project. As well, the Commission has the authority to decide whether NETE Southwest is qualified to be a public utility, which is what the Commission is compelled to do in this docket. With respect to staff's independent analysis in this docket, it is worth describing how staff's analysis occurs. After NETE Southwest filed this application February 28th, staff has reviewed thousands of pages of information filed in this docket, conducted its own investigation through the issuance of discovery requests into a multitude of matters ranging from emergency response plans, construction materials, to costs on Kansas consumers. In addition, staff reviewed nearly 100 discovery requests of the 10 other parties in this docket. After reviewing all of the information and conducting its own analysis, staff came to its own independent conclusion of whether a certificate should be granted to NETE Southwest. Staff set forth its conclusions in its May 17th report and recommendation. The report goes into finite detail. The report describes the nature of the docket, statutory standards, and analyzes the standards by applying evidence factor by factor. When it addresses each factor, staff paraphrases the position of NETE and staff's own response analysis of that position. The public version of staff's response of staff's report is 270 pages. Staff's confidential competitive report is 1,165 pages. In short, contrary to assertions otherwise, staff did conduct its own independent analysis and critically review the positions of all parties in this docket. So, to conclude, staff recommends the Commission approve the settlement agreement based upon its determination that the project is needed, that NETE Southwest has demonstrated its financial, managerial, and operational ability to construct, own, and operate transmission facilities in the state of Kansas.
Thank you, Mr. Tennant. This now concludes all of the opening statements. The next step is to begin the examination of witnesses. We've now been going for, by my reckoning, approximately almost an hour and 50 minutes. It's time for a break. We're going to take a break. So let's take a 15-minute recess. I have, my time shows at 10:47. Let's take a recess until 11:04, 11:05. We stand in recess until 11:05.
Hi, this is
Okay, we'd like to do a hearing check. Can everybody hear me?
Yes, yes, I can hear you. Is this Becky?
This is Becky Walby with NextEra, yes.
Okay, all right, thank you.
And this is Andrew Schulte on behalf of NextEra. We're sharing audio, so I want to make sure that you can hear me as well.
Yes, I can. Yes, thank you.
Thank you.
Michelle, can you hear me?
Yes, I can. Are you ready?
I believe we are. Denise, are you ready?
Yes, I am. Thank you.
Very good. It's 11:05 a.m. at this time, and we will go back on the record. The next phase of this hearing involves the examination of witnesses. Let me give you kind of an overview of how we're going to approach the cross-examination process. I'm providing for the commission, if it wishes to do so, to ask questions first. If commissioners desire to hold their questions until other interveners have asked their questions, that's their option. But if they care to ask their questions in advance of the other questions being asked, they may do so as well. With that having been said, Mr. Schulte, I will turn to you and ask if you would please call your first witness.
Thank you, Chairman Keene. Just a quick technology note. I am sharing audio with the witness, and so my screen will remain on mute, and I may not show up on your computer if my box is not pinned. So, but we do have Ms. Walding on behalf of NextEra Energy Transmission Southwest available and ready to testify.
All right.
Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Good morning, Ms. Walding.
Good morning.
Nice to have you with us. Let's turn first to see if there are commissioner questions. I'll turn first to Commissioner Duffy.
Would you, Chairman Keene, would you
Yes.
like us to enter her testimony into the record before Commissioner
Certainly.
questions?
Certainly, I think that would be appropriate. Please do so.
Okay, thank you. Just some quick standard questions. Please state your name and business address.
My name is Becky Walding, and my business address is 700 Universe Boulevard, Juno Beach, Florida.
Ma'am, could you please maybe move closer to your microphone or speak up a bit?
Sure, yes. So my name is Becky Welding.
Thank
I work for NextEra, and my business address is 700 Universe Boulevard in Juno Beach, Florida.
And by whom are you employed and what is your title?
I am employed by NextEra Energy Transmission, and my title is Executive Director of Development.
Are you the same Becky Walding who filed direct testimony on February 28th, 2022, rebuttal testimony on May 27th, 2022, and testimony in support of the settlement agreement on June 7th, 2022?
I am.
Do you have any additions or corrections to make to your testimony at this time?
No, I do not.
If I ask you the same questions again today as appear in your pre-filed testimony, would your answers remain the same?
They would.
I will also note for the record that the verifications attached to the rebuttal testimony of May 27th and the testimony in support of the settlement agreement on June 7th include verifications signed by Ms. Walding, but those have not been notarized due to travel. And we can certainly update the record with notarized verifications if the commission deems it necessary, or if given that Ms. Walding is under oath right now and affirming that that is her testimony, whether that is sufficient.
You have a motion?
With those notations, we would move to submit the direct testimony, the rebuttal testimony, and the testimony in support of settlement agreement as pre-filed in this case.
For the stipulations as indicated by Mr. Schulte, is there any objection? Without objection, the testimony is entered into the record. Thank you.
With your indulgence, Chair Keen, I would also like to point out that there was an affidavit of Becky Walding that was attached to a pleading in this case. We would also, I could also ask a few foundational questions for Ms. Walding and then move to submit that as well.
Please proceed.
Ms. Walding, did you review and sign an affidavit in your name, which was attached to a pleading that was originally filed on May 16th, 2022?
I did, yes.
And was that pleading corrected in order to provide a missing page from the affidavit on June 6th, 2022?
Yes.
And with that affidavit corrected to include the missing page and an attachment thereto, just affirming that attachment was also reviewed by you and incorporated into the affidavit?
It was, yes.
With that, we would move for the admission of the affidavit as corrected on June 6th, 2022. And I can give you the name of the pleading. The name of the pleading on June 6th, 2022 was titled Note on Corrected Filing. And then the original pleading was titled NextEra Energy Transmission Southwest LLC's response to the petition to intervene of Darren McGee and Rochelle McGee Smart and motion to strike, or in the alternative, response to unsubstantiated factual allegations. We are just moving for the admission of the affidavit that's attached thereto.
Very well. Is there any objection? Without objection, the affidavit is admitted.
Thank you. With that, we would tender the witness for commissioner questions and cross-examination.
Thank you very much, Mr. Schulte. Okay, very well. We'll restart that effort again. Let me turn to my commissioners and see if they would like to ask questions at this time or defer. I'll begin with Commissioner Duffy.
Good morning, Chair Keen. I will defer at this time. Thank you.
Thank you. Commissioner French.
Thank you, Chair Keen. Good morning to all the parties. I will also defer any questions to follow the parties crossed. Thank you.
All right, thank you as well. Ms. Walling, I do have some questions for you. If you have access to the pre-filed testimony that was filed by Kelly Harrison on behalf of Evergy.
Yes, we do. And could we pull it up?
We could do a screen share on it, or we
yes,
have we can grab a binder if you'll give us just a few seconds.
Sure. I think it would be easier than the screen share.
Okay, the witness now has that testimony in front of her.
The marvels of the electronic age, right? All right, fair enough. Are you familiar with, have you read Mr. Harrison's testimony?
Yes, I have.
All right, let's take a look for a moment here at page 8, lines 11 through 13, if we could. And I'll read into the record what appears on lines 11 through 13. And again, this is Mr. Kelly Harrison's testimony on behalf, direct testimony pre-filed on behalf of Evergy. It says, and I quote, as discussed in NETE SW's application, its bid of $85.2 million in 2021 is approximately 40% less than SPP's initial cost estimate of $142.6 million. NETE Southwest bid is also $31.4 million, or 27% lower than the next bid. Ms. Walding, did I accurately portray what appears on lines 11 through 13?
You did, yes.
So my question to you would be this. Are these statements, in your judgment, factually correct?
No, they are not.
All right. In what respect are they not correct?
That they have doubts that we would be able to construct the line for 85.2 million.
Well, that really, in all fairness to you, that is not the question I'm asking.
Okay.
I'm not asking for your interpretation. Well,
okay.
let me not confuse you. I'm not trying to trick you here in any respect. All I'm trying to do by my line of questioning is really directed toward performing what I think is one of the major responsibilities I have as a commissioner, which is to see that the applicant meets the burden of proof in its application for the CCN. That's what my questions are about. Notwithstanding, so
well, what I can answer is,
are there factual inaccuracies within that statement?
no, Chairman, there is not factual errors in those numbers.
Okay. Yeah, I wasn't asking for any conclusions that you might reach or differences of opinion that you may undoubtedly have. Let's take a look, if we could, next to Mr. Ives' pre-filed testimony. Page 4, lines 1 through 5.
Okay, we are pulling it up.
Thank you.
Okay, we are at that.
All right. And for the record, let me read in a portion of what that says.
Mm-hmm.
This again is testimony by Mr. Darren Ives, who is an executive with Evergy on behalf of Evergy. And it's just pre-filed testimony. Beginning on line 2, actually, it says much of the information restricted to confidential competitive, in this case, is public in other jurisdictions, allowing customers as well as parties to the regulatory proceedings the ability to review, understand, evaluate, and monitor the costs and conditions being imposed upon them. What is your take on this statement and this contention? Is it factually correct?
It is factually correct. Oh, look, I just want to make sure. Much
Please.
of the information, are you asking me if the information that is restricted here is public in other jurisdictions?
That is exactly the question.
That is inaccurate.
Okay. Could you elaborate?
Sure. It's different region by region. And so that vast majority of regions do not share the competitive confidential information that we have secured. So the vast majority do not. There may be one, and I would have to review that more closely, that does, but the vast majority do not.
Okay, thank you for that. My next line of questioning really tries to drill down on some provisions within the settlement agreement, if you have that available. And in particular, I would begin with page 16 of the settlement agreement. Tell me when you have that.
We are pulling it up.
Okay.
Okay, we have it available.
All right, thank you very much. Let me read into the record the first two sentences of paragraph 16 of the settlement agreement. It says the provisions in this agreement have resulted from negotiations among the settling parties and are interdependent. In the event the commission does not approve and adopt the terms of this agreement in total, it shall be voidable by any selling party, end quote. Have I accurately read from a portion of paragraph 16 of the settlement agreement?
Yes, you have.
Okay, here's my question for you, Ms. Walding. What's your take on the parameters and scope of what is voidable? Let me give you an example. If, for example, the commission were to find that any of the conditions that are set out for NextEra to comply with within the purview of the settlement agreement either needed to be modified, changed, or that there were additional conditions that should be added to those, does that thereby render the settlement agreement voidable?
Chair Keen, I'm not sure the witness has the legal background to respond to that question.
Well, with due respect, again, this is not a trick question. Let me pursue this a little further with your indulgence, Mr. Schulte. Ms. Walding, did you participate in the negotiation on behalf of NextEra in the settlement agreement?
Yes, I did.
All right. So my question's a pretty direct one. You're a senior executive within NextEra, are you not?
I am, yes.
And I'm going to guess within the purview of your responsibilities, you with some frequency review various legal documents, and you may or may not seek legal counsel in interpreting those, depending upon the circumstances of the document. So I'm simply asking you, within the purview of your understanding as a negotiating party to this document, if, again, it appears to be a take it or leave it provision with respect to the commission. That is my concern. It seems to say that if the commission modifies the settlement agreement by either changing some of the terms of the conditions that appear herein, or it even was to add additional conditions if that might be necessary in the public interest and to protect Kansas ratepayers, that could make this entire document voidable. That's not a trend. That means that you could basically, I presume, at NextEra's wish or at its option, it could deem this document to not be effective. My question is that correct or not?
Yes, it is. I think I'm not trying to avoid the question, but I think it would have to be in consideration of the terms of the overall terms of if there's minor modifications, I don't know that NextEra would mind that. But what we did come to an agreement in this is that some of the major terms are dependent on each other. And that's what that language is meant to say, in my non-legal opinion, is that, the settlement was done as a whole and the pieces and parts of it hold together for us. And so minor changes by the commission would not be opposable by us. It's just some of the major pieces are what we're more concerned about.
Well, I appreciate the answer. I think it's a very straightforward, a very candid answer. I appreciate it. So I would ask, maybe as a follow-up to that, what would be the time parameters for NextEra, in your case, to contend that the settlement agreement is voidable in the event the commission were to add additional conditions or change the conditions within the settlement agreement as a condition of the CCN?
I think NextEra could decide that within a couple business days. It could be turned around fairly quickly.
Okay, let me kind of ask it in another way. Like, again, Mr. Schulte, I'm not trying to ask any trick questions. I'm not trying to transgress anything that may be in your purview, but I am really wanting to kind of drill down on what the meaning of certain aspects of this settlement agreement really are. So basically,
Chairman, I did want to clarify one thing I just said.
Sure,
too.
please do.
Depending on the size of it too, it could be something we could turn around quicker than the couple business days that I mentioned. And so once again, going to the fact that, if it's not major changes, that's something that we could probably consider quickly for you.
Okay, I anticipate then that, given what you've just said, that certainly the time allotted for reconsideration, if you were dissatisfied with some aspect of the commission's decision, or the time for appeal after reconsideration would be the outer time limit. Does that sound reasonable?
That does sound reasonable, yes.
Okay. If we can, let's take a look at page, again, within the settlement agreement, please. I believe it's page 13.
Page 13.
Page 13. Mm-hmm.
Okay, we are there.
Thank you very much. It's helpful when you tell me you're there. I'm grateful for your courtesy there. What I want to talk about here now is those provisions of the settlement agreement that provide for the waiver of statutes, primarily Kansas statutes, exclusively Kansas statutes. And some concerns I have about that, and see if you can maybe allay my concerns. I'm looking specifically on page 13 to subparagraph M, the very bottom paragraph. Do you see that?
Yes, I do.
And for the record, again, I will read a portion of this into the record. It says that the settling parties agree that FERC preempts the KCC's rulemaking authority as set forth in KSA 66-101B-F 66-117, 66-128, and 66-128A through P, unless NETE Southwest acts outside the conduct covered by FERC jurisdiction. I'll stop reading at that point.
I just want to make it clear that it's rate making authority and.
It's what?
that
Rate
it's
making. Can I
rate
leave that
making.
out?
Well, I think you said rule making, and so I just want to make sure.
My
it's rate making.
apologies. It is rate making. Yes. Yes. The first line should read, the settling parties agree that FERC preempts the KCC's rate making authority. Right.
That's correct. Mhm.
All right, fair enough. Let's take a look, if we can. Give me just a moment here and get my records and notes in order here. Let's take a very brief look at some of these provisions of Kansas law that by this particular paragraph appear to be beyond the reach of the commission jurisdiction in this matter. Let's take a look, for example, at KSA 66-101B, 101D, 101E, and 101F. These have to do with the efficient and sufficient service of the facilities as well as rates. In accordance with the settlement agreement, these provisions would be, except with an exception, these would be waived and would be beyond the purview of the commission to look at. How is the interest of Kansas ratepayers and the public interest served by that exclusion?
Chair Keen.
Yes.
May I offer some explanation?
Please do. Please do.
So this language was based on some previous transmission only utility certificate settlements. And I would also note that it is limited to the settling parties agreement. And it is also limited to rate making authority. And then finally, the last clause of that sentence states that the commission will decide the applicability of these statutes if NETE Southwest acts outside of the conduct covered by FERC. So the language was specifically written to allow the commission to find that the applicant has acted outside of the activities that are covered by FERC, specifically, those rate making activities, and apply those statutes. It's simply an acknowledgement from the settling parties that the rate making authority of over this project will reside at FERC.
So then by accepting the settlement agreement, the KCC would exceed, in your judgment, I guess, to the settlement agreement's FERC preemption contention regarding these statutes. Is that correct? With respect to rate making?
Yeah, and you will notice that provision of the settlement, well, I'm sorry, I may not have understood that question. Would you mind restating that?
I can try. What I'm asking you is that if the commission were to accept the settlement agreement as it now exists, would the KCC in effect accede to the settlement agreement's preemption contentions regarding the its rate making authority under these statutes?
I don't believe so. And you'll notice that several of this is the only, well, I'm just flipping through to make sure this is an accurate statement. But okay, so subparagraph A and subparagraph M specifically reference the settling parties agreement. So it's an agreement among the settling parties. The other provisions of the settlement agreement are not couched in those terms. And so I believe that, I mean, those provisions, at least in my opinion, other parties may have different opinions, but in my opinion, those terms are limited to an agreement amongst the parties with a recognition that the commission will apply its laws as it deems appropriate.
Well, I think that's fair. That goes back really to the earlier line of questioning that I had with Ms. Walding, to be sure. So, Ms. Walding, let me go back. You're the witness here. We haven't forgotten you. Again, one of the statutes, looking back at M, that is to be accepted here is 66-117. And 66-117 is a little bit trickier here because it concerns practices and services in addition to rates. This isn't exclusively rates. So are we to anticipate that it would only be among the parties with respect to rates that this would be for preempted?
Yes, that is accurate.
Okay. If we go take a look again, if you would, at M, I didn't read the last sentence which leads into the next page, but the next sentence indicates that the parties do not object to waivers of KSA 66-1402. Do you see that provision?
Yes.
Okay. Well, by my reading, what 1402 does is it ensures that the KCC receives notice of affiliate contracts and can review them for fairness to Kansas customers. Yet, if the literal terms of this document are adhered to, and the KCC accepted the settlement agreement as it is, we would forego that opportunity. Do you understand my concern?
Yes, I understand your concern. And so that's why we listed here that we have will file a list of the affiliate contracts specific to the operations and maintenance and reliability of the line.
Okay. I didn't mean to interrupt.
I was just going to continue reading part of what's in I, little I, and a summary of the material changes to any of those contracts.
Okay, fair enough. Let's take a look, if we might, to at page 11 of the settlement agreement, paragraph 10D. Do you have that?
Yes, I do have it.
Thank you. Let me quote 10D into the record. It says, NETE Southwest will consider and address as part of its line citing proceedings an option to double circuit 25-mile portion of the Wolf Creek Blackberry project that parallels an existing Evergy 120 kV 161 kV transmission line, subject to receiving necessary approvals for a change in the project scope from SPP and the necessary agreements from Evergy. I think my question really here is quite succinct. Does that mean that NETE Southwest may opt not to do a double circuit pertaining to these 25 miles of parallel line?
That is not currently the project scope. And so what this statement is saying is that we will consider and address it in the line routing and the line siting proceeding. And so what that means is that we'll come back to you and address it as part of that proceeding.
Okay. Will that entail additional costs for the project?
We have not evaluated it at this point as whether or not it would have additional cost. And so that's why we did want to do that as part of the line siting proceeding, is because we have not evaluated that.
All right, fair enough. Thank you. Let's turn back once again. I have just two more questions for you. Well, it's a series of questions. They're kind of related here. Let's turn back to Mr. Harrison's testimony again, pages 24 through 26. Start with 24.
Okay, we're there.
All right. What I'm turning to is the summary portion, really, of Mr. Harrison's testimony on behalf of Evergy and some of the conclusions that he has reached. And in regards to some of the conditions he believes the CCN should be subject to. Now, I'm going to have an opportunity to examine Mr. Harrison in due course, but I would like to ask you some of the questions that he raises concerns about within the context of whether or not, under the settlement agreement as it exists and as you understand it, whether these matters have been addressed. That's the core of my question, if you follow me.
Yes, I follow.
The first of these concerns begins on line 24 on page 24, and it has to do with, and I'm going to paraphrase this, his concern about what constitutes force majeure and what constitute changes in law. And he asks those questions within the context of cost, prospective cost or cost containment.
Chair Keen,
Yes.
some of the language that we're reviewing is confidential.
Take a look, if you would, Mr. Schulte, for me, at page 24 through the end of Mr. Harrison's testimony. Is all of that confidential?
No, there is asterisks and underlining under the portions that are confidential. And some of it, we have declassified some of it from confidential competitive to regular confidential.
If I may interrupt, Mr. Schulte, yeah, I can see where the confidential portions are underlined. I will ask questions that aren't underlined.
Okay.
So that we may continue in the public forum. If you have concerns about whether or not I've done that, please speak up. All right. Let me rephrase my first question, if I might, Ms. Walding. The settlement agreement contains force majeure provisions and it contains changes in law provisions.
So that portion is underlined. And the reason it is confidential, and that portion is confidential, not confidential competitive. But it was made confidential because it is part of the competitive bid. The competitors for transmission projects compete specifically on cost cap provisions. And the formulation of those cost cap provisions have become a big part of the competitive nature of the bids. And we have agreed as after negotiations with Evergy and others to allow that high level information to be marked as regular confidential, not confidential competitive, so that their internal team can see it for the purposes of reaching a settlement in this case. However, it still must be marked as confidential because we need it to be not publicly available, and it also pursuant to the commission's standard protective order, confidential information can only be used for the purposes of this case. And so we still believe that those protections are necessary for that high level information about the cost containment.
Very well, I accept your explanation and I'll move on. If I turn to the next page, on the second concern that is stated by Mr. Harrison, and I will not refer to anything else again that is underlined within the context of this test of this examination.
Chair Keen, it looks like we have a hand raised from Rustin Kimmel.
May I be recognized?
Mr. Kimball?
Yes.
Okay.
May I be recognized? Commissioner, to the extent that council is making an objection here regarding the discussion in a hearing as to particular matters, I would like to raise my objection to his objection pursuant to KSA 66-106. No person designed to be present at any hearing of the commission shall be denied admission. So I just want to, at the first available opportunity, to raise that concern. I'm doing so here because I don't think that any person should be excluded from hearing the information that's being presented to the commission pursuant to the state statute. Notwithstanding, I understand the commission's order that's in place, but I don't believe that order can trump the statute.
I don't know that the order trumps the statute, but I think it's in harmony with the statute. The statute is 66-1220A, and it states the Kansas State Corporation Commission shall not disclose to or allow inspection by anyone, including but not limited to parties to a regulatory proceeding before the commission, any information which is a trade secret under the Uniform Trade Secrets Act. It cites KSA 60-3320 et sec and amendments thereto, or any confidential or commercial information of a corporation, partnership, or individual proprietorship regulated by the commission unless the commission finds the disclosure is warranted under several of 4 factors. Based upon that, I would overrule the objection. What I will do is I want to continue with this line of questioning, Ms. Walding. My first question now becomes the second over on page 25 of Mr. Harrison's testimony.
And sorry to interject. To be clear, I am not objecting to this line of questioning. I am just pointing out that we should go into confidential session in order to address it.
Are you suggesting that we need to go into confidential session with respect to all questions pertaining to matters addressed on pages 24 through 26?
Only the asterisks and underlined information.
Okay. Well, I've committed to you that I won't refer to any more of those provisions again in the context of this line of questioning. You have that commitment. If I transgress, you call me on it.
Thank you.
All right. At the top of page 25, Ms. Walding, it says the commission should require NEAT Southwest to provide a specific example as to how its cost caps are going to be determined. Is that provided for within the settlement agreement, or was it a matter that was negotiated in some respect in conjunction with the settlement agreement?
It was shared in conjunction with the settlement agreement. It has already been shared.
Okay. If you could maybe put the microphone a little closer to.
Sure, yes, of course. And I'll speak up a little bit more.
Okay. The third point that Mr. Morrison highlights is that there should be quarterly updates. And I believe, as I read the settlement agreement, there are quarterly updates that satisfy this provision.
That is correct, yes.
Fourth, it asks that the commission requires NEAT Southwest to have an established, not just the plan, but an established emergency response plan, including how it intends to communicate with the commission regarding interconnecting utilities, governmental agencies, landowners, and so forth. Does the, in your opinion, does the settlement agreement as it exists now address this concern?
Yes, it does.
How so?
It requires, let me go to the settlement agreement, to this portion of the settlement agreement.
Sure.
And we're getting there ourselves. Just a moment, we'll give you a page.
Sure, that's all right.
And so it's on page, page 15 of the settlement agreement.
Okay.
It's under little I3, and then the C portion of that. And what it says is that these are the documents that will be filed upon completion of the project, and that includes a storm outage and emergency response plan.
All right, thank you. I'm back to page 25 of Mr. Morrison's testimony. And the fifth concern he has, which is that the commission should require NEAT Southwest to provide proof that it has resolved the galloping issue that has plagued existing generation interconnection lines that NEAT Southwest operates and maintains in Kansas. Your response to that?
Yes, that is included in the settlement agreement as well. And so I would like to go to the settlement agreement and again, and point to the specific area where that's at. It is on page 12. It is I. And it says that NEAT Southwest will provide the KCC staff with a copy of the galloping study referenced in its response to data request number 21. And in the design and construction of the project, we will seek to limit the galloping issues by incorporating mitigation methods derived after we do the engineering studies.
Okay. So the tangible steps that NEAT would take to resolve this problem are still prospective.
And I would defer to Mr. Mayor's testimony as the expert of galloping. But yes, there is engineering that will still need to be detailed when the line is complete.
Okay, very good. My final line of questioning to you for that, we need to turn back to Mr. Ives' testimony once again, if you would, please. Page 19 through 21.
Oh, yes, we're there. I'm
Okay,
sorry.
thank you. Okay. Again, it's a similar process that we went through with respect to the concerns that Mr. Morrison had. These at the time, Mr. Ives provided them were a list of the conditions that he thought should be contained within any approval the commission would grant. Let me focus, if I could, on number 6 at the bottom of page 19.
Okay.
And he says here, it says the amount to be placed in Kansas rates should be capped on the amount in NETE's bid, with the only exception being for changes in the project ordered by SPP. Your take on that, and is that directly incorporated within the settlement agreement?
I'm reviewing that. We had to change over to a document, a different document. So let me review that portion just a second.
Take your time.
Okay, I would like to go to the settlement agreement.
Okay.
Good. And so we're going to page 10 of the settlement agreement.
Okay.
And it's part B. And in part B, we said that we would include caps and conditions consistent with the bid as part of our rates that we file with the Federal Energy Regulatory Commission.
Okay. I appreciate your noting that. The questions I have with respect to that provision, I'll save for Ms. Finnis. Again, and I can do this with Mr. Mayers as well, on page 20, number 11. That expresses specific concerns about the galloping issue.
Okay, we're getting there. Just a moment.
Okay.
Okay, we're at number 11.
I'm at 11. I put you through all of that just to say that I'm going to reserve basically my question having to do with the galloping for Mr. Mayor. I suspect that would be your preference as well.
Yes, that would be.
Okay, I have 2 more questions and I'm done. Let's go back up to number 7. Again,
Okay.
we're on page 20, if it's there. You have that?
Yes, we do.
Let me read into the record. NETE Southwest should not be allowed to put the cost of generation lead lines and substation facilities into Kansas rates if they do not directly service Kansas customers. Further, NETE Southwest should be required to report any generation lead lines or substations constructed that will be utilizing the WC/BB 345 kV line. Is that particular concern addressed within the purview of the settlement agreement?
Yes, it is addressed in the settlement agreement. And first off, we do not put generation lead lines into Kansas rates.
Okay.
And so that is addressed just as a matter of the way that the market and SPP works. Those are already not a part of rates. And then the part on the settlement agreement that I would like to go to is on page 12. And what it's number 1, or little L, it's a little L, I'm sorry. At the bottom of page 12, it starts at the bottom of page 12.
See that?
And it says that we will comply with all applicable statutes for any future proposal to extend or relocate an existing transmission line, obtain an ownership interest in anything, in an ownership interest in an existing regulated electric facility in Kansas, or construct a new transmission line. And so what that means to me is that we have to follow the rules that are set forth by the commission, and that item would be included within these rules of things that we could include in rates, and that the commission has authority over in the CCN process.
All right, thank you. My final question bears on paragraph 12, again on page 20, the very bottom of the page, carries over to page 21. What Mr. Ives does here, if I can summarize it, and you can correct me if you think I incorrectly do that, is the sorts of quarterly reports he believes are specifically important to adequately provide the KCC with information concerning the line, the operation of the line. My question to you is, in your opinion, are each of these reports alluded to by Mr. Ives encompassed within the purview of the settlement agreement?
Let's go to page 15 of the settlement. And little I, what do I call that? Two little I's.
Okay.
It lays out the quarterly construction reports that we have agreed to file in compliance. And so what it lays out is anything in respect to safety, cost, schedule, quality, landowner issues, and resolutions. And that's similar to what the commission has required in similar other citing dockets.
Okay. But I take it you would acknowledge that within the purview of that portion of the settlement agreement to which you just alluded, it is somewhat less specific than the various line items that are referred to by way of reporting within Mr. Ives' testimony within paragraph 12.
Let me do a quick comparison, if you wouldn't mind me giving me a moment.
Please do.
I do agree it is a little bit less specific. Number one, this is what the parties agreed to as part of the settlement. But generally, you know, I do think all of the items are covered in terms of, you know, what they're asking about is what part of the project is completed. You know, what's the spend to date? You know, what's the budget of compared to the budget of the project? And so to me, like those would be covered under cost. Schedule would be covered under the % completion of the project. And then there's a few other things that are more general. And so we think we've covered the vast majority of what was asked for, including down at H and I, the safety reports and the landowner complaints and issues.
All right, thank you very much. That concludes my questioning, Ms. Walding. I very much appreciate your indulgence, your patience, and the candor of your answers as well. Let's go on a bit further in our cross-examination at this point. At this point, I will turn to KIC and Mr. Zakura.
Thank you, Chair Keen. Just an item, if you or David can answer this, I had distributed exhibits and labeled those exhibits, and I'm going to have some of those to be presented to Ms. Walding. Are they available to the commissioners now so that I could proceed in that fashion? And to the parties. I've served everyone and gave them my best shot at an index so that we can keep together. So may I proceed on?
Yes, you may. Please do. The commission has those exhibits available.
Okay. Thank you, Chair Keen. Ms. Walding, good afternoon. I had to check. I'm Jim Zakora. I'm representing retail ratepayers. Good afternoon.
Good afternoon.
I have a few questions for you, please. And I would first ask you, Ms. Walding, to turn to KIC Exhibit 28. Tell me when that's before you, please.
That's before me.
I need to pull it up too. 1 minute.
Oh, just one more minute.
I need to pull it up as well. Thank you. Okay.
If I could, for the record, Ms. Walding, I'm identifying KIC exhibit number 28, and it's directed to NextEra Energy Transmission Southwest, and it's order granting abandoned plant incentive, and it's dated February 7, 2022. Do you have that before you?
Yes, I do.
I have a question for the commission. I can move this as an exhibit into the record, or we could take administrative notice. Does the commission have a preference as to either? If there's no preference, may I move for the admission of KIC 28 into the record?
Thank you. I was going to suggest that, but I was on mute. So is there any objection?
We would object to relevance. There's been no showing of relevance of this document to the matters before the commission.
I'm going to overrule. I'm going to overrule. Give Mr. Zakura an opportunity to proceed.
Thank you, Ms. Walding. Now, can you describe generally what this order does? As I understand it, it allows NextEra, can I just say NextEra for purposes of examination, NextEra to recover amount that you've financially committed to the project today. Is that a fair characterization of it?
No, that is not a fair characterization. And you can see in the first paragraph that it is only to recover the prudently incurred cost if the project is abandoned or canceled for reasons beyond NextEra Energy Transmission South's control.
Okay, please excuse me, you're correct. This deals with recovery of costs in an abandonment situation. Would that be correct?
That is correct, but it's not, it has to be an abandonment situation that is beyond our control.
Okay. Would you agree that it's an abandonment, if this would cover an abandonment situation for reasons beyond your control?
I would agree, yes.
Okay. And what would be permitted to be recovered under this particular order when there is an abandonment for reasons beyond the control of NextEra?
So what occurs if there is an abandonment that is beyond our control is that we would have to seek recovery of the prudently incurred cost in front of FERC. And there would be a proceeding that would be held such that people could review and challenge the cost, including FERC, that we are seeking to recover.
And would that be part of your formula rate, or what would be the mechanism for recovering that?
The mechanism would be that we would do, I believe it's a 205 filing with FERC. And then it would, if it is approved, the amount that would be approved would be included in our rates and NETE Southwest rates.
And with those rates, would those, any of those, Ms. Welding, would those costs in that situation, would those be recovered through participating members of SPP?
Yes, they would be.
May I please ask you, Ms. Welding, to turn to page 2?
Okay, I'm there.
Are you there? Okay. And I direct your attention to the top paragraph. And it talks about requests that NETE Southwest requests certain transmission incentives. Do you see that part?
Yes, I do.
And one of those incentives is a 50 basis point return on equity incentive for participating in a regional transmission organization. Is that correct?
That is what the document has, yes.
And would that RTO be SPP?
It is for SPP, yes, in this case.
Now, if I could go further on item number 2,
I do
it
want
talks
to.
about.
Okay. Go ahead, Andrew.
Go right ahead. I'm sorry, I didn't mean to stop.
Yeah, we object to questions related to the details of FERC's rate making process, as that is outside the scope of this proceeding.
May I be heard on that? This is directly related to the process, and let me tell you why. The commission has before it the issue of whether or not that they will, under Kansas law, permit the Blackberry line to go forward, and for that to be charged under the appropriate rates to the various members of SPP and ultimately retail ratepayers. This provides that this is information regarding what would happen if, for instance, the commission in one set of circumstances said we will not give a certificate for this, or we condition a certificate, and for some reason the conditions are not acceptable to NextEra. And what this does is basically kind of round out the record, if I would say, as to what the costs of the filing are here.
There is no probative value to this discussion, given that these are standard rate making process under the jurisdiction of FERC. So since they are generally available to all transmission projects in the country, there's nothing specific about this project that we will learn by going down this path of questioning.
You're speaking, excuse me.
I'm going to overrule the objection and allow Mr. Zakura to continue to pursue the questioning. Please continue.
Thank you. If I might, Ms. Welding, please direct your attention to that same paragraph.
Okay.
And does that indicate a hypothetical capital structure for recovery in the stated circumstances of 60% equity and 40% debt?
I'm sorry, Mr. Zakura, could you repeat the last part of that question?
Excuse me. Does the paragraph 1 set forth a hypothetical capital structure of 60% equity and 40% debt?
It does. And I just want to clarify, though, that this is not applicable. These rate making parameters are not applicable to the project. The project has its own rate making parameters that are a part of the bid, and they're part of the confidential and competitive information as part of our bid. So I just wanted to make sure it's clear that this is more of a form rate making structure. It's not an applicable rate making structure to the project.
Ms. Welding, I think we said as a premise that this is solely related to the set of circumstances that you earlier described, and that is if there is an abandonment for reasons beyond the control of NextEra. That's correct.
No, that is not correct. Because we made concessions as part of our bid on our rate making structure for that specific project. And even if that specific project is abandoned.
If I may interject as to relevance, I would like to renew my objection as to relevance. If you review the beginning of paragraph 2 of this order, it states as background, on November 3rd, 2017, the commission issued an order accepting a NETE Southwest filing that included a formula rate. So this formula rate was in place for NETE Southwest, which owns more than this Wolf Creek to Blackberry project. And it was in place prior to the 2019 ITP. And as the witness has testified, the specific rate making restrictions that NETE Southwest offered as part of its bid would supersede these provisions. Therefore, this is irrelevant to this project.
May I be heard on that?
Yes.
I'm just trying to conduct an examination on a document. The objection of counsel is improper. The appropriate objection, if he wants to make one, is relevance. Then the commission can ask what the basis of it is. What we don't have in Kansas is what he is doing, which is called speaking objections. And the reason we don't have that is because that amounts to coaching the witness. I am entitled to ask the witnesses questions. Counsel is entitled to object and not answer on behalf of the witness. And I am truly trying to move the proceeding along and not be difficult, Chair. Would you like me to continue?
The objection, for the time being, the objection is overruled. Please continue.
Ms. Walding, have you had occasion to calculate what the costs of NextEra are to date for the project?
No, I have not.
Now, it's kind of a matter of form. If I could, Chair Keen, I would like to present to the witness KIC 44. And that's the answers to the data requests of KIC that were served last evening, I believe around 5 or so. Do you have those before you?
No, we do not yet. Can you repeat what the number was?
No, I do not have that.
Okay, I sent it to David. May I identify them for the record?
Please.
And I apologize for the commission that this happened last evening. It's the last exhibit on the list. It is the information request and response of NextEra to KIC 2-06, 2-01, public, 2-02, 2-04, 2-05, and 2-11. Are those before the witness? Yeah.
Jim, can you tell me exactly when you emailed that so I can find it? Because I don't think I have that.
Okay.
And so I don't think the commissioners have it.
May we take a 1-minute break so I can do that?
We will. Let's take a break.
May we please have a 5-minute break?
We will. Let's take a 5-minute recess. It's now 12:17. Let's resume here at 12:25. So we're in recess until 12:25.
Jim, was it the email you sent me at 7:13 that's titled "Scan from a Xerox multifunction printer"? Because that's got 2-06 and a public version of 2-01 and 2-02 and 2-04 and 2-05. Jim, staff just knocked on my door and said they think the email you sent at 7:13 p.m. is the one you're referencing. Can you just confirm that? Because nothing here is labeled 44.
Michelle, are you there?
Yes, I am. Ready to start again?
Okay, Denise, are you ready to continue?
Yes, I'm ready.
All right. It's now 12:25 and we're back on the record. I'm trying to see if I can see Mr. Zakura again.
Before we resume, Chair Keen, just a question on the schedule about.
Andrew, your lips are moving, but I can't hear a thing you're saying.
I can hear him.
Speak again, Andrew.
Yeah, I'll try again. Sorry. Just
You're
a question as to schedule. Can you hear me now?
Yes, please.
Just wondering what the timing will be for lunch, and it may be appropriate to inquire as to the amount of cross-examination left for this witness.
Yeah, let me take care of it.
Thank you.
Mr. Zakura, are you back on?
Yes, I am. Thank you.
Okay, very good. Thank you. We do have some issues concerning some timing issues here. I do want to admonish all the parties. The commission wants to provide all the due process we possibly can. We want to give all the parties. I don't know where that feedback is coming from.
And somebody's in an engine shop, I think.
Michelle?
No, he's on mute.
Okay, it's gone. Can you hear me?
Am I to proceed?
Can you hear me? Just hold on,
Yes.
hold on 1 minute, Mr. Zakura. Can everyone hear me now? Am I back on? Okay, thank you. I just want to remind everybody that the time parameters that I indicated at the outset of the hearing are the ones we intend to adhere to. We have a lot of ground to cover. We have a lot of witnesses to cover. We want to provide a due process to everybody. We want to have everybody ask the questions you wish to ask that are focused on the issues before us, because it's important for the commission that we develop a complete record. That's what we're about here. But so we do have an issue of lunch coming up. Mr. Zakura, I would ask, do you have any ballpark idea of how much time your additional cross-examination of this witness might take?
I would think no more than 15 or 20 minutes.
Okay, well, my preference would be for us to finish with Mr. Zakura's cross and then take lunch. And then we'll resume after we come back, and we're going to proceed. Our intention, to answer your question directly, Mr. Schulte, is, as I indicated before, is to finish all of the NextEra witnesses by the close of business today. That is still the goal. If we don't do that, we have no prayer, because we have so many witnesses behind them. But that's our goal. Our goal is to complete the witness list for NextEra. Having said that, Mr. Zakura, let me turn back to you again. If you would, please resume your cross-examination. I would remind Ms. Walding, we did take a recess, but you remain under oath on the record. Thank you. Mr. Zakura. Mr. Zakura, you're muted.
Now, I apologize to the commission for the mix-up on Exhibit 44, but I believe Mr. Cohn, excuse me, has received that and hopefully has distributed it. Ms. Walding, do you have what's been labeled as Exhibit?
Jim, I have not received it.
I just resent it.
Okay, well, it hasn't come through yet.
Okay.
Don't have it.
Okay.
Mr. Zakura, I believe what will happen here is that as soon as Mr. Cohen receives it, he'll transmit it to the commission.
Okay.
If the parties have it, I might suggest that they screen share it. But that is presupposing that the parties do have it.
NETE Southwest. NETE Southwest has what we believe is the referenced exhibit, but we'll need confirmation.
Oh, I thought I did that, but here it goes. It's exhibit response to KIC 2-06, 2-01, public, 2-02, 2-04, 2-05, and 2-11.
You don't have 6.
There were 2 scans. 06 was on a separate scan.
Okay, so those were the ones you sent at 7:13 last night and are titled scan from Xerox.
That is correct, yes.
Okay, I will distribute that.
Tell me when I may proceed, Cherokee.
I'm waiting for the commission to receive it, Mr. Zakura. Mr. Schulte, do you and Ms. Walding have access to it?
Yes, we do.
Okay. Bear with me for just a moment. I'd like to have the commission have it in hand before we continue your cross-examination.
Chairman, this is Heather Starnes.
Yes.
Do we have, I noticed when that was sent, it is not a numbered exhibit. Is Mr. Zakura referring to it with a particular exhibit number so I can keep my exhibit straight?
Yes, Ms. Starnes, it's exhibit 44.
Thank you. Just want to make sure I have my numbers correct.
Are both documents exhibit 44?
Yes. Both scans.
Okay. Mr. Cohen has just transmitted to me. The other 2 commissioners, have you received it as well? Document 44. Might refresh and see if you have it. Commissioner French has it. Commissioner Duffy. Okay, the commissioners have it. Mr. Schulte, do you and Ms. Walding have it as well?
Yes, we do.
Okay. Mr. Zakura, I think you can continue.
This is going to be a little anticlimactic, but I'll go ahead. Ms. Walding, do you have before you what's been labeled exhibit 44, which is the response of NextEra to KIC 2-06, 2-01, 2-02, 2-04, 2-05, and 2-11. Do you have those? And are you the same Becky Walding who signs the verification of response on those exhibits?
Yes, I am. I will note that there was one error on number 201. If you go to the bottom there, that the sponsor is Daniel Mears, but my signature was applied in error. And so I did want to note that.
Well, for purposes of authenticating these exhibits, would you agree that these are the answers to KIC exhibits from NextEra?
Yes.
Now, I would like to have you turn your attention, please, to exhibit your response 2.02.
Okay, I'm there.
And as I read that exhibit, subject to and without waiving objections, other than its interconnection points, NETE Southwest is not aware of any planned electricity delivery points from the Wolf Creek Blackberry 345 kV transmission line project. Is that a correct reading of that statement?
That is correct.
And is that statement to mean that currently there are no planned delivery points except to the the substation of Associated Electric Cooperatives in Jasper County, Missouri?
That is correct.
And if I could please ask you to direct your attention to 2-04. Do you have that before you?
Yes, I do.
And does that also indicate that there are no, well, I'll just read it to you. Subject to and without waiting needs subject Southwest objections. NETE Southwest is not aware of any planned or contemplated electricity delivery points from the project. Is that a correct statement?
Yes, that is correct.
And if I could, direct your attention, please, to 2-05. And I would direct your attention to NETE, to the response which says, subject to and without waiving objections, NETE Southwest is not aware of any planned or contemplated connection of wind facilities and or solar energy facilities into the project. Do you see that?
That is correct. Yes, I see that.
Okay, so when we put those together at this point in time, there's no delivery points other than the AECI point, and there is no interjection points into the line at this time, or that you're aware of at NETE Southwest.
I just want to correct the terminology of using a delivery point as AECI. It's actually an interconnection point. And the distinguishing fact I'm making is that electricity can go either way. A delivery point is usually a one-way direction, but this is an interconnected line connected to the overall transmission system on both ends.
Certainly. I believe I've moved, correct me if I'm wrong, have I moved, I don't recall, for admittance of 44, KIC 44? If I have not, I would do that at this point.
Unmuting helps. No, you hadn't as yet. It's been moved. Are you moving now that you're admitting 44?
I'm a little bit, I'm struggling a little bit with whether we're admitting just the DRs that were just discussed, or if we're admitting all of the DRs.
It's all of those listed in 44. I did not ask questions on all of them, but that is exhibit 44, which I'm asking admission of.
Okay, I'll just need a minute to confirm whether we have any objections. Okay, thank you for your indulgence. Thank you for your indulgence. We do not object to the admittance of exhibit 44.
Are there any other parties that have objection? Hearing none, 44 is admitted.
Ms. Walding, I would please ask you to turn your attention to page 37 of your initially pre-filed testimony, your first direct pre-filed testimony.
Okay, just a moment while we gather it. What was the page reference again?
The page reference was 37 of the public document. Please tell me when you're there.
Okay, we're almost there. Just one more minute. I mean, one more second. Okay, we're ready.
And I would direct your attention to lines 12 through 15, please. And at those lines, it says, according to SPP's 2019 ITP assessment. That begins that way, okay? So my first question is, NextEra did not do any independent assessment. Is that correct?
That is correct, yes.
And then as I continue on, it says, the addition of the project, quote, will help to levelize system LMPs, load generator LMPs in the west and high load LMPs in the east, and overall system congestion while providing market efficiencies and benefits to ratepayers and transmission customers. Do you see that?
Yes, I do.
The first thing for the record is, will you define what an LMP is?
It's a locational marginal price.
And what do you mean when you use, what do you understand it to mean when SPP says will help levelize system LMPs?
What I understand that to be is to levelize pricing across certain areas, and levelizing meaning make them balanced.
May I please ask that the witness be presented with KIC Exhibit 42?
I don't believe the commissioners have 42.
We do have access to that.
David?
I will provide that.
Got it. Thank you.
Tell me, Chair Keen, when I may proceed, please.
You may proceed. The commission now has KIC 42.
Now, do you have that before you, Ms. Walding?
Yes, I do.
I would ask you to turn to the second page of that exhibit. Well, first, let me identify it. It is identified as the State of the Market Report, September 2021, Southwest Power Pool. And the second page, do you see that?
Yes, I do see that.
And I want to read from the first paragraph. Average prices for the summer period were the highest in entities around Southwest Missouri and portions of Oklahoma, and lowest in Western Kansas and Nebraska. Do you see that?
Yes, I do see that.
And above that, there's all of these listed points like KMEA, Sunflower, Midwest Energy, and most of the ones in Kansas, as I observe, are substantially below the average line. Do you see that?
I'm going to object as not relevant to this witness's testimony and outside the scope of what she has testified to.
I'm going to allow some, Mr. Zucker, please. I'm going to allow some latitude here, Mr. Schulte, so that we can at least try to determine, give Mr. Zucker at least an opportunity to try to make the point he's making. Please continue, Mr. Zucker.
Well, I'm referencing the effect of levelizing prices, which is on paragraph 37, excuse me, page 37 of Ms. Walding's testimony. And if I could, Ms. Walding, also direct you at the bottom of that page. Over the past 12 months, entities around Southwest Missouri and Eastern Oklahoma saw the highest prices overall, while entities in the northern part of the footprint and in Western Kansas saw the lowest prices overall. Western Kansas has abundant low-cost generation, primarily wind, and while the northwest portion of the footprint has primarily low-cost coal and hydro generation. Typically, entities in those portions of the SPP footprint see some of the lowest prices overall. Do you see that, Ms. Walding?
I do see that.
When you use in your testimony and quoting SPP, that this project will help to levelize system LMPs. Does levelize to you mean that those prices which are lower will be brought to a medium, and those prices which are higher will be brought to that medium as well?
It can occur that way. That's directionally right. It doesn't always occur exactly to the medium, but that is directionally correct.
Now, I have asked, excuse me, KIC has asked you, excuse me again, KIC has asked NextEra and SPP about specific Kansas benefits and costs and how it might affect the state of Kansas. Would you think it would be important for the commission to know if the BlackBerry line went into effect, if the energy prices in Kansas would materially increase to the medium?
I object to the form of the question. I don't understand. Well, is the question whether this witness thinks it would be important for the commission to know? I'm not sure how that can be answered. The witness is not a commissioner and is not a legal practitioner in Kansas.
May I be heard on that?
Yes, please.
It was a hypothetical. It wasn't asking her if she was a commissioner or anything else. It was asking her, and if you want me to phrase it this way, do you think it's important that the commission know if the BlackBerry project will increase prices for electric energy in Western Kansas?
I still object to the form.
Overruled. Witness may answer.
Would you mind repeating the question for me one more time?
I'll do my best.
Do
you believe?
Pardon me, Mr. Sakura. Denise, can you go back and repeat the question? If not, we'll understand that too. Denise?
Denise is muted with your line to reply.
Sorry about that. Okay.
Could you repeat the question Mr. Sakura asked of Ms. Walding?
Yes. Mr. Zakura stated it was a hypothetical. It wasn't asking her if she was a commissioner or anything else. It was asking her, if you want me to phrase it this way, do you think it's important that the commission know if the BlackBerry project will increase prices for electric energy in Western Kansas?
It's hard for me to understand what the commission finds important on this.
Can I proceed?
Yes, please do.
I believe your testimony was directionally that equalizing prices would cause prices that are below the median to increase and prices above the median to be reduced. Is that correct?
My testimony was that the prices, it would be levelizing system LMPs.
That wasn't my question. My question was, in the levelizing, do you agree that those below the median would rise in price and those above the median would fall in price? Isn't that what levelizing means?
And Mr. Zakura, I did answer that earlier, that yes, that generally the prices do move in those directions on levelizing.
Okay. Now, just a few more questions if I could, Chair Keen.
Okay.
I believe in the testimony, your testimony, you generally speak of the Blackberry project as being part of the overall ITP program of reducing congestion. Is that a fair representation?
That is a fair representation, yes.
And congestion can cause prices to be lower. Is that correct?
No, congestion generally drives prices higher. Because what it doesn't do is it doesn't allow all the generation that's economic to dispatch. And therefore, congestion drives prices up in general.
Let me ask you this, and going back to this exhibit 42. Well, let me do one clarifying question. When you talk about congestion making prices higher or driving prices higher, you're talking about across the whole region, isn't that correct?
It can be across the region. It can be localized. It depends on where the congestion is occurring.
Let me ask you this. In the zone, for example, Sunflower Electric, right? You're acquainted with that, aren't you? You have facilities in that western half of the state.
I'm not familiar. I am not part of the NextEra Energy Resources arm.
Well, let me go back, and I won't spend much more time on this, Chair Keen, but let me go back to the bottom of the second page of this, if I could. It says Western Kansas has abundant low-cost generation, primarily wind, while the northwest portion of the footprint has primarily low-cost coal. Okay. It goes on to say typically entities in these portions of the SPP footprint see some of the lowest prices overall. Do you see that?
I do see that.
Would you agree that the abundance of wind energy in the western half of Kansas has been a factor in that part of the state having comparatively lower energy costs than the remainder of SPP?
Mr. Zakura, I do not believe that I'm the right witness to testify to that. I do believe that that would be a good question to address to SPP.
I have a question, if I could, Chair Keen. I could go ahead, I can introduce this exhibit through SPP later, or I can introduce it now. I don't think there's any dispute as to its authenticity.
I would suggest you go ahead and introduce it at this point.
Okay. I would move that KIC 42 be admitted into the record, and it is a 3-page exhibit. The first page is titled State of the Market, Summer 2021. The second page is page 33 of that document and page 34. And it includes figures 4-6, price by load serving entity in the summer. Figure 4-7, price by load serving entity rolling 12 months. I would move that that be admitted into the record.
Is there any objection? Without objection, it's admitted.
I believe, Chair Keen and Commissioners, I've concluded examination of this quality. I thank you for your consideration and for and accept my apology for the delay with the exhibits. I'm doing my best to move this along.
All right, thank you very much, Mr. Zakura. At this time, we are going to take lunch. We're going to take a break, and I'm suggesting roughly 30 minutes. So it's now almost 12:55. Why don't we resume here at 1:30? And accordingly, we will recess, and we're now off the record. Michelle, can you hear me? Michelle, are you there? Denise, are you there?
Yes, I'm here.
As we round up Michelle and we can get a full screen, we'll probably start.
Sounds good.
Did you have enough time to at least have something to eat?
Yes, I did. Thank you.
Okay. Michelle, are you there?
I see a
Michelle?
cursor moving around the screen, so it looks like somebody from IT is on it.
We're going to give him a call here.
It's Michelle. It's Trump.
Okay, it's 1:30 and we're back on the record. We're now looking for counsel and a witness. Mr. Schulte, that's good. And Ms. Walding, thank you. We appreciate your being back here. Can you hear us all right?
Yes, we can.
Andrew, I can't hear you if you're speaking. Ms. Walding, can you hear us? Is your microphone working?
Yes, we can hear you now.
Okay, very good. Very good. It's 1:30. We're back on the record now. When we recessed for lunch, Ms. Walding is on the stand. You're on the stand virtually once again. And I would remind you that you remain under oath. And the next cross-examination will be by Mr. Kimmel on behalf of the McGees. Mr. Kimmel, please.
Chair Keen, would you mind if I raised a scheduling preliminary issue?
Go ahead.
Dr. Loomis, the fifth of the NextEra witnesses, is not available tomorrow morning. I don't know if we're going to get to him today, but if the parties even have any cross-examination for him. So I guess it would be appreciated if other counsel could let us know if there will be any cross for Dr. Loomis. And if so, I just wanted to note that he is available this afternoon, but not tomorrow morning.
All right. It wasn't intended to be a head fake by me. Our intention is to finish with all of the NextEra witnesses by the close of business today, whatever time that is. That is our goal. We're going to finish it. And we will be finished with this hearing by tomorrow night at the end of this as well. So that being said, I'm open for any suggestion you might have as to the order of witnesses to accommodate that witness.
Does I guess, could we hear from Mr. Zakora and Mr. Kimmel as to whether they do have cross-examination for Dr. Loomis or the commissioners?
Sure.
I will have cross-exam, but it will not be extensive.
Commission staff? Commission staff?
Commission staff will not have any questions for Dr. Loomis.
All right. I could poll the commission, I guess. I have no questions for him. Commissioner French, do you have any questions?
No, I would not. If I had any, it would be based on other parties' questions. So no.
Fair enough. Fair enough. Commissioner Duffy, any questions?
I will not, again, unless raised by another party. Thank you.
Thank you. Mr. Schulte, we have Mr. Kimmel's questions of Ms. Walding. Then we may have commissioner questions after that. We would have your redirect of Ms. Walding to whatever extent there is that. And then we are concluded with Ms. Walding's testimony. It's your call. If you wish to have him go immediately after Ms. Walding so that that's done, we can do it.
I appreciate that. We will get back to you after the next recess or after we finish with Ms. Walding's testimony.
All right, fair enough. All right, I'm sorry for the interruption here. Mr. Kimmel, the floor is yours.
Thank you, Commissioner. Ms. Walding, my name is Rustin Kimmel. I'm an attorney for Darren McGee and Rochelle McGee Smart. At the beginning of your testimony today, they introduced into evidence an affidavit that you signed on May 16th. Would you bring that out, please? And I'll refer to you to paragraph 4 of that affidavit.
We are pulling it up. If you'll just give us a moment. Okay, I am at that affidavit.
I'll read the first sentence there on paragraph 4. It states, NETE Southwest takes seriously its relationships with property owners and seeks to engage with all property owners in the project area.
Excuse me, Mr. Kimmel, could you please slow down in your reading?
Absolutely. I'll read the first sentence of paragraph 4 again. It says, NETE Southwest takes seriously its relationship with property owners and seeks to engage with all property owners in the project area with the utmost courtesy and respect. Did I accurately recite what was written there in paragraph 4, first sentence?
You did, Mr. Kimmel.
Are those your words?
Yes, they are.
Is it correct to say that you have engaged with all property owners in this matter?
Yes.
I'll refer to you what was previously entered into evidence preliminary as McGee Exhibit 1. You pull that up.
I don't believe McGee Exhibit 1 was entered into evidence.
It absolutely was.
Was it part of the stipulation?
Commissioner, this is one of the 2 exhibits that NextEra stipulated to introducing into evidence at the beginning of this hearing, or before the hearing actually started.
They have been introduced. They were introduced this morning.
Thank you for the clarification.
Do you have a copy of McGee Exhibit 1 in front of you, Ms. Walding?
Yes. Yes, I do.
This is, would you tell the commission what McGee Exhibit 1 is?
It's an option agreement and transmission easement agreement.
Prepared by NextEra
Yes.
Southwest?
Yes.
Was this option agreement one of the auction agreements that you provided to all the landowners?
No, not to all the landowners. We provided it to certain landowners.
Which landowners did you provide it to?
Objection. We cannot, first of all, we can't reveal any landowner names as that is confidential personal information. Secondly, any specific negotiations with landowners is outside the scope of this proceeding, it may be relevant in the to be filed citing proceeding.
Sustained.
When you say that you didn't give it, you did not provide it to all property owners, what's your definition of a property owner, Ms. Walding?
My definition of a property owner is anyone that could potentially be in the direction of this line.
Ms. Walding, I will represent to you, well, your affidavit, your May 6th affidavit was attached to a May 16th pleading that NextEra filed in opposition to my client's petition to intervene. Do you understand that?
Objection to the extent it requires, I'm not sure what it was attached to is relevant. It's only the affidavit that is Ms. Walding sponsored. The pleading is a legal filing by the attorneys, not by Ms. Walding.
Mr. Kimmel, could you rephrase the question?
Ms. Walding, your affidavit was filed in support of a pleading filed May 16th by NextEra, correct?
Again, the pleading is not relevant.
Overruled.
Yes, I believe it was.
And you're familiar with that pleading, correct?
No, I didn't write the pleading. I am familiar with the affidavit.
I'll represent to you that your pleading indicated there were 197 property owners within the project area. Does that sound right to you?
That sounds approximately right, yes.
How many of those 197 property owners did you send the option agreement to? Or did NextEra send an option agreement to?
Objection as to relevancy. This is a citing issue.
Overruled.
I do not have a count of how many landowners.
Did you send them to half of the property owners?
I do not have any count at all.
Who would know that information?
I would have to get with the land agents and specifically get a count because it even actually changes day by day. And so it's difficult to give you an exact number right now.
When was the last time that you asked the land agents how many property owners you sent the easement or presented the easement to?
I don't really have a specific date that we do that. We sometimes get updates of where the land agents are. And so I wouldn't have a specific date I could provide you, Mr. Kimmel.
When you received your last update from the land agents, how many of property owners had they presented easements to?
As I told you, Mr. Kimmel, I didn't count. I didn't go through that report and try to count those landowners.
Is it NextEra's normal course of business to send these option agreements to landowners?
Yes, it is a normal as part of many different siting processes, not just for transmission, but as part of other obtaining other property rights as well.
Ms. Walding, I'll also direct you to what's previously been marked as McGee Exhibit 3, which was previously entered into evidence in this case. Let me know when you see it.
Yes, I have it up.
What is McGee Exhibit 3?
It is a survey permission form.
Isn't it NextEra's normal course of business to send these survey permission forms to property owners?
Yes, it is.
Do you have any idea how many property owners you presented these survey permission forms to?
I do not have a count. I'm sorry.
Who would know that answer?
Our land agents that are out in the field.
Do you have regular correspondence with the land agents, Ms. Walding?
Objection. This is really getting into the citing process.
I'm gonna overrule this. Let's see where this leads. Witness may answer.
No, I do not directly have regular communication with the land agents. I have people on my team that have regular communication with the land agents, but I myself do not have direct communication with them regularly.
Ms. Walding, I'll refer to you to your affidavit that we've been, your May 16th affidavit that we've been speaking about, in paragraph number 7, in which you state, nor have NETE, Southwest, Doyle, or the other land agents threatened landowners with the taking of property through eminent domain, period. Are those your words?
Those are my words, yes.
How do you, please explain to me, if you don't know the landowners in which have been presented option agreements or access agreements, the scope of the interaction that your land agents have had with those landowners.
I'm sorry, Mr. Kimmel. I think your question stated, as I heard it, if you do not know those agents, and I have not testified that I do not know the agents.
Well, then I misspoke, and I apologize for that. I think the gist of my question was clear to you, however. Nonetheless, Ms. Walding, would you please explain how you can testify that your agents have never threatened landowners if you don't know which landowners your agents have contacted?
Because it is a matter of conduct, and it's a matter of the conduct that we expect, not only of ourselves, but also of anybody who's working under our direction, that they do not threaten landowners with the taking of property through eminent domain. It is our direction and the direction of which they work for us under.
Give me 1 second, please. Ms. Walding, as part of your normal, as part of NextEra's normal course of business, they hold public meetings with landowners, correct?
That is correct.
And in fact, NextEra Energy Transmission held a public meeting remotely on March 22nd of this year, or actually 2 hearings on March 22nd this year, correct?
That is correct, yes.
Commissioner, on my exhibit list, I had identified a couple of videos. Those videos were extremely large, so I wasn't able to email them to the commission. However, I'll represent to the commission. I think Ms. Walding will probably acknowledge that the videos are on NextEra's website. I'd like to admit those 2 videos dated March 22nd, 2022, one starting at 10 a.m., the other starting at 7 p.m. into evidence.
NETE Southwest objects as to relevancy. Those meetings were in preparation for the citing application. Those will be at issue in the citing proceeding. It is premature and irrelevant to this proceeding.
Mr. Kimmel, can you more specifically identify the content of these videos again, please?
These contents include statements from NETE Southwest. Are you asking me for the location of the website or the?
Well, that would be helpful to anything you can to more specifically identify exactly what it is you're asking to be admitted.
Pardon
my interruption, but I'm not so sure that those videos are in our possession. Mr. Cohen, are they in our possession?
Chair Keen, no, they're not. Mr. Kimmel emailed the parties and said that they were, as he stated, too large to upload. So he did not provide them to us, nor did he provide links to them.
All right, thank you. Yeah, Mr. Kimmel, what I'm asking you to do is to try to be as specific as you can in identifying what it is you're seeking to have admitted.
Okay, there's, and what I would recommend, and I'm happy to do that. I'll get the video. And I have a hard copy of the video that I can forward to the commission. These are two videos that are on NextEra's website. Their Wolf Creek Energy Transmission website. Hold on for just a second. Can we go off the record for a minute, Commissioner?
Yes, we're off the record. Let's go back on the record. Mr. Kimmel, let me ask you this question. Could you not, as a substitute for requesting the introduction of these videos, so specifically identify those videos on the record at this point, where they can be found at the website you're suggesting, and have the matters handled in that way?
Sure. I get the problem is I'm having trouble finding it on I have the YouTube video of it. It's on YouTube. I can give the YouTube link. I think that Ms. Walding will acknowledge. I would hope that she would acknowledge that these videos are posted on their website, and I'll be happy to follow up with the commission at that point. And I could play the videos. There's one clip that's about a minute that I'd like to play for the commission. But I'd like to introduce the entirety of both videos and evidence. And I apologize for the confusion, but I just could not get the videos to email to the commission because of their size. The YouTube URL for the morning session is youtube.com/watch?V XWD0UW lowercase p NR1U.
Mr. Kimmel, if you could just email that link as well.
Just email it.
Mr. Kimmel, let me make this suggestion to you. Let's go ahead and proceed. We're holding up the hearing, I think, unnecessarily. And I say that in the context of you have yet a witness to present of your own.
Sure.
Why don't we defer this until that point and maybe get this sorted out between now and then, so we're not admitting into record something that's nebulous. So I would ask you to continue with your cross-examination of Ms. Walding, if you would.
This is the last questions that I have, Your Honor. Or excuse me.
Okay.
This is it.
Thank you.
Ms. Walding, are you familiar with a Tracy Davis?
Yes, I am.
Who is Tracy Davis?
She is our internal legal counsel.
Will you acknowledge that NextEra has posted videos of their March 22nd meetings on NextEra's website?
Yes, I did acknowledge that. Yes.
With that acknowledgement, Commissioner, I understand what you're asking about trying to introduce these with my witness, but I'd ask the commission to admit the videos into evidence subject to later production. And I'll try to get those to you tonight.
We would have, NETE Southwest objects as to relevancy. And if I may explain further, these meetings were held as open houses for landowners to learn about the route of the line and to provide feedback on the route of the line. It is a legal requirement in Missouri to hold those meetings prior to filing a certificate application. And it is a best practice in Kansas that has been done by every transmission developer that I'm aware of before filing a line siting case in Kansas. Therefore, it is directly relevant to the line siting proceeding and not to this proceeding.
And I'd like to respond to that.
Please do.
Yes, as Mrs. Zakura said, speaking objections are not appropriate here. However, in regard to the public meeting issue, there's a public meeting requirement associated with the siting application. That's not implicated here. This video is being introduced to demonstrate that NextEra has made threats to take property owners' land from them using eminent domain. That goes directly to NextEra's failure to comply with Kansas statutes that prohibit such demands or such threats.
Mr. Kimmel, subject to a ruling at some point on relevancy, I'm a bit at a loss as to why, if you choose to introduce it and you can with somewhat more specificity identify why that could not happen in conjunction with the examination of your witness.
This would be a record of NextEra's, and it'd be more difficult. It'd be easier to introduce through NextEra. I simply want to play the video. It's about a minute worth of statements here, Your Honor, and we'll conclude my cross-examination.
Is the video available to be?
Right now it is, yes.
Oh, it is.
I'm going to share my screen and play it.
Mr. Schulte?
We would object to playing the video as that. I assume it would be transcribed by the court reporter, which then would be part of the record. And so it's equivalent to entering it as an exhibit, which we object to for the reasons already stated.
All right. Mr. Kimmel, let me ask you this question from me. Why would this matter not be more appropriate if and when we get to the citing for part of this proceeding?
My client's argument in part is that NextEra does not have the managerial capabilities necessary to support the commission's issuance of a certificate of convenience and necessity. The managerial capabilities is one factor that is evaluated by the commission. NextEra's failure to comply with state statutes, in particular, their failure to comply with statutes that prohibit the conducting of business and their failure to comply with the specific language of the statute that prohibits the taking of land through eminent domain until a siting permit is issued is at issue here. Those actions that NextEra is taking reflect upon their managerial capacity, which is direct.
I get your train of thought here. Michelle, are you there?
Yes.
Michelle, yes. If you would, let's have the commission retire to a breakout room. We will go off the record at this point and go to a breakout room. As soon as we're finished, we'll return.
Are you having all members?
The three commissioners plus counsel, David Cohen.
Okay.
Plus Brian Fedotin.
Okay.
Michelle, if you could bring up the full screen again, please. There we are. We're back on the record. We've returned from executive session. It's our determination that we are not going to pass on relevancy this time. At this point, it's possible that it has tangential relevance. We're just not going to pass on that. We are going to allow Mr. Kimmel to share the screen and to play the video.
Thank you, Ron. Again, give me 1 second.
Okay.
Chair Keen, this is Denise. Usually I do not record in my transcript the actual words from a video. Do you want me to transcribe that or just make an indication that a video was played?
In this case, I would appreciate it if you would transcribe it.
Okay.
Thank you for asking. And Mr. Kimmel, if you need the assistance of our IT staff in affecting what you're trying to do, I think they can help. I think you've got it. I think you're sharing screen.
I think I got the line.
I don't believe that's the one you want.
Help us with. So again, the question is, what happens if a landowner does not agree to allow this project across their land?
Sure, Marcus, thanks for that question. So, yeah, I mean, as you mentioned in your discussion, you know, our goal is to really be a good partner. We're going to be here for quite a long time in the area, and we want to have good collaborative relationships with our landowners and neighbors. So, you know, understood that there may be some folks that just don't want it on their land, and we certainly understand that. So, you know, I think the part of this process is understanding where landowners are and understanding, you know, feedback that they may have. I think at the end of the day, you know, this project will be a regulated public utility project. And so, you know, once the route is finally approved by the applicable regulatory agencies, the Kansas Corporation Commission and the Missouri Public Service Commission, then, you know, we would have eminent domain authority for the line. That's certainly not our preference to start there. You know, we would hope to, you know, get voluntary agreements with landowners as much as we can before going to that process.
Now, Mr. Kimmel, just for the record, I heard a video. I didn't see an audio. I mean, I heard the audio, but I didn't see a video.
Chair Keen?
Sure. I'm sorry.
David?
The link Mr. Kimmel sent out was for a different video. The one he just showed is labeled evening, and the one he sent was labeled morning. So I think I would ask Mr. Kimmel to send the correct link out and also identify the timestamp of when he started playing.
Sure. The timestamp that I started playing it was 1 hour and 17 seconds, I believe. I'll send the link right now.
Do you have another video, Mr. Kimmel?
Yes, I'm sending out the link to that second video that Mr. Cohen said. These are the two videos that I referenced in my exhibit list that I would like to have entered into evidence. Both videos address the same issues associated with, you know, NETE Southwest demand that the landowners provide them with easement agreements where they'll take their property via eminent domain at some point down the line.
Objection. This is statements of counsel. The video speaks for itself. This is a misrepresentation.
Sustained. Let's play the videos, please. Or have them transmitted and then we'll play them.
Those are the two videos that I sent that I wanted to play. And my only question for Miss Ms. Walding, is did you recognize Tracy Davis's speaking in that video that was just played?
Yes, I did.
That's the only questions I have, Your Honor.
Okay, thank you very much. Thank you, Mr. Gill. Let's move on. Next up would be commissioner questions. Let's see if we have any commissioner questions. I'll begin first with Commissioner Duffy.
Thank you. I just want a clarification. The audio that we heard was a recording from one of the 2 meetings, Ms. Walding, that was held in, can you tell me the location where and who the population, landowners in what counties? If you could clarify that for me, I'd appreciate it.
Sure, it was a virtual hearing or virtual setting. So it wasn't in a specific location, and landowners throughout the area were invited, and we had multiple of them to allow for people to attend at different times. And so I'm not sure like which landowners attended which sections, but we had multiple of them.
Okay, if I could follow up, the question that was being asked by a landowner, or was that a pre-prompted question?
No, that was in response to a landowner question asking if the project would have eminent domain. And so what Ms. Davis was referencing is that it's not our intent. We try to work with the landowners. It's important to us to be a part of the communities. And so therefore, once this project is approved, then it would be subject to eminent domain after it has its regulatory approvals. And so it's our objective, if we're asked questions by the landowners, to not lie to them and to tell the truth.
So is it typical of the company to hold these meetings, take these surveys prior to receiving authorization by the commission for, for example, why you all are here before us today? Is that your normal course of business throughout Kansas and other states?
Well, this is the first time that we've done one of these in Kansas. So it is the first time. And so we did, plan this such that it would be done and we could have landowner feedback and address any concerns prior to us submitting the line routing application.
Okay. Your response in the RFP from FERC, how many times have you been the successful respondent on a FERC RFP?
So I'll couch it in terms of how many of the projects have been competitively bid. We win about 40% of the ones that are won by what we call non-incumbent. And so the utilities that are existing, we win 40% of those nationwide. So we have a very high percentage, I would say probably 10 projects about.
Okay. And in the RFP that was issued by FERC for this project, the statement of no solar, no wind will be added. Was that part of the RFP that you responded to?
Yeah, so the RFP was issued by SPP.
I'm sorry, by SPP.
Yeah,
right.
That's okay. And so, no, it just didn't specify that there would be. And so it's not currently a part of the design. And so the design that was issued by SPP was an interconnecting line that just interconnected at 2 locations. And so that's what they were requesting to be built. And that is what met the economic need of the region.
Okay.
So it didn't ask for any additional interconnections in the RFP.
Okay, and I believe you've already shared that an interconnecting line is not a one-way line, correct?
That is correct, yes.
Okay. I do have a question. In your submission, and Evergy did express some concern, and my understanding in the settlement agreement that you've agreed not to interconnect to the plant, inside the plant boundary. It would be outside, correct?
Yes, that was a stipulation that we agreed to in the settlement that Evergy did request. And so we are going to interconnect outside of their boundary.
Will that affect the project monetarily or in terms of the success of the project, the end stated goal?
No, it will not. And so it's just allowing the interconnection point. The line still operates the same as it would before. It just moves where it changes hands between us and Evergy at a different location than what SPP had identified as the interconnecting point.
Okay. Another clarification for me, if you would, regarding your emergency plan. My understanding is, I believe the staff and the company, Evergy, did not think it was robust enough and really spot on in terms of the word emergency response. So the settlement agreement does speak to that. And I guess my question is this new territory for you in terms of the emergency response plan that you will establish? Or I would think this would be a protocol that you would have followed previously in other projects.
You're exactly right. I mean, we own about 11,000 miles of high voltage transmission lines throughout the nation. And so this is a very standard program and plan for us. But I will also point to Ms. Sweezer Fisher is going to also testify onto the operations plan. And so she could give more detail on that.
Okay, very good. That's all I have. Thank you, Chair King. And thank you, Ms. Walden.
Thank you, Commissioner Duffy.
Thank you, Commissioner Duffy. Commissioner French, any questions of the witness?
Yeah, I'll be real quick. I did have some questions sparked on levelizing LMPs and congestion relief, but I think those are probably more appropriate for SPP and their witness. So I'm going to reserve that. The one question that actually Commissioner Duffy just raised, I thought was really good, and I wanted a little more definition on it, is the impact of moving the interconnection point from inside the Wolf Creek boundary to outside, and what financial impact that might have. Feel free to tell me this is a better question for Evergy or for our staff, but it sounds like those facilities to get to the new interconnection point outside the boundary, they're still going to have to be built by someone. I assume that someone is now going to be Evergy. Is that correct, that those costs now will not be taken on by NextEra, they will be taken on by Evergy?
And so there might be some costs. I think Evergy's witness might be best to answer their portion of it. It's a very, very small distance. I will say that. And so I do think that would be a better question. And also on our side, Mr. Mayers can help with that as well.
So it's not a matter of different ownership of a new substation or transformer. You would own all the same facilities. That point of interconnection would just be located in a different geographic place.
Well, there's a little bit of difference in the facilities. And so the background behind this is that Evergy, wanted to build inside of their nuclear substation, so that we were not accessing the inside of their nuclear substation territory. And so that's why we moved it. And so it is a short distance, but that was the overall driver of it. And so.
Yeah, I think I understand the rationale. I guess I'm more getting at the potential rate making impact. So I will reserve some of those questions. Thank you. That is all I had.
Thank you.
Thank you. Commissioner Duffy.
I'm sorry, I did see that I had one more. So Ms. Walding, when we talk about the proposed site that you included, that you based your costs on, and based on the next step, if you're approved, the next step, it's oh, well, we need to deviate here, deviate there, make a corner turn. Are those allowances, since you guys are experts at building transmission across the nation, do you build in some sort of factor for the very fact that you're not going to be able to maybe build it as you proposed it?
Yes, and so we do take that into account, as well as another item that we added on our cost containment is that any of those reroutes that we have to do will be subject to the cost. Oh, sorry, I might be getting into competitive confidential information. I apologize. Andrew.
Yeah, sorry, Commissioner Duffy. There are provisions of the cost cap at issue here. And so we'd be happy to answer these questions, but we would need to do so in a confidential session.
And I appreciate that. Thank you. And I'm not requesting that right now, but that may be something later. And again, I would look to my fellow commissioners if they have any interest of pursuing that line of questioning. So that's all I have. Thank you.
Thank you, Commissioner Duffy. Ms. Walding, I do have two follow-up questions, and they're very brief. One pertains to the, I'll call it the McGee exhibit, the one that is the option agreement and the transmission easement. You need not look at it. You can answer the question without that. If you need it, you can. But I guess my question is, I'm not asking you to specifically identify any landowners whatsoever. But what I am asking you is, have any landowners who were offered these easements or options executed, signed, or accepted these in Kansas?
Yes, several.
Do you know how many? Do you know how many?
I do not off the top of my head.
Okay.
I could come back later with that number.
Okay, if you could give us that number, I would appreciate that. That concludes all the questions from me. It concludes all the questions on cross. I'll turn to you, Mr. Schulte, if you have any redirect.
Yes. I'm sorry, I unmuted my computer by habit, but I forgot that I have a microphone here. Just briefly on the redirect, I do want to note, though, for all the parties' planning purposes, that Dr. Loomis is available to take the stand after we can complete the redirect of Ms. Walding.
All right, well, thank you very much. With my apologies to you, Ms. Walding, I have two questions. I have one left, and I promise you it is the last. It goes back to the first question I asked of you. You need not turn there. I'll try to refresh your recollection adequately. If I don't, we can go back to the page that we referenced to start the my part of the cross-examination. But one of my first questions had to do with Mr. Harrison's direct testimony, his statement about the fact that NETE Southwest, in its application, its bid was approximately 40% less than the SPP initial cost estimate and roughly 27% lower than the next bid. Do you remember that conversation early this morning?
I do, yes.
Yes. My question to you is, you have a lot of experience. You've exhibited that here. You have a lot of fact-specific knowledge about this particular industry. Why would you guess that that was the case? Why would you guess that NextEra's bid was so below not only the estimate of SPPs, but the other bidders? What would be your business judgment reason for how that happened?
Oh, yes, it's very clear to me. NextEra builds more than anybody else in this industry. We are the largest builder, not only in this industry, but we're also in the top 5 in the entire nation of any industry. And so what that affords to us is a lot of buying power and a lot of ability to negotiate contracts and negotiate supplies at a rate that we think is extremely competitive. As an example, we build about 16 billion is what we built last year. And so to the fact that an $80 million project within a $16 billion spend, you know, it really affords us the ability to negotiate strongly with our suppliers.
Thank you for that answer. If I could rephrase what I think you just said, I think it was that you enjoy probably many economies of scale and perhaps some of scope. Is that fairly correct?
That is correct, yes.
All right. The redirect is finished, the cross is finished. Ms. Walding, I think.
I'm sorry, I did have redirect.
Oh, I thought, I didn't realize that. The floor is yours, Mr. Shelty, for redirect.
Okay, thank you. This won't take long. Mr. Zakora asked you some questions about some LMPs going up in some parts of the state and other LMPs going down in other parts. So related to that, what is the overall rate impact to Kansas? Do you have any numbers or studies that you can share on that?
Yes, and so I would like to go, if we could, to the SPP's 2019 ITP assessment. It's part of my exhibit.
BW3. And what page are you?
And as part of that, I would like to go to page 146 in the document or 157 in the PDF.
And okay, before you go further, let's just confirm that parties have had an opportunity to get to that page. Is the commission ready?
We're ready.
Okay, thank you. Please continue.
So on this page, what it shows is it shows the benefits of the projects that were proposed by SPP. And it compares those benefits to what it says is a 1-year ATRR, which is a transmission revenue requirement. And so you can see in the right column, it has what is the net benefit. So after customers have paid for the transmission line in Kansas, and the economic benefits have been measured in Kansas, that the net impact to customers was a 9-cent decline in their overall cost. And this includes the cost of their energy, as well as the cost of the line. So what it tells you is that they, across Kansas, Kansas received less expensive power. It covered the cost of the line and gave more benefits than even the cost of the line.
Are these figures for the entire portfolio or for Wolf Creek to Blackberry specifically?
They are for the entire portfolio. And so that's a good question. So I would also like to move in this same document to page It is on page 14 of the PDF, page 3, starting on page 3 of the document itself. And so what this list is, and it starts on the page earlier, it's a list of what are all the projects that are a part of this SPP portfolio that they are approving. And so you can see there's several projects, but I'll point you to the type column. And so the type column, you can see towards the bottom, there starts to become a few projects that have an E. located in them. And so the ones that have Rs are driven by reliability needs. The ones that have Es are the ones that provide economic benefits. And that's why they have to have enough economic benefits in order to be a part of this list and suggested by SPP. And so you can see the list of the projects that actually provide economic benefits is 9 projects is all. And so I'll take you now through the cost column. So you can see that the projects that they were recommending were all very low in cost. Except when you come to on page 15 of the PDF, where the Wolf Creek to Blackberry line is called out.
Sorry, page 5.
Page 4 in the document or 15 in the PDF.
Thank you.
You can see the cost of all the projects is fairly low, except there's 2 projects that are high in cost, and one of them is the Wolf Creek Blackberry, and the other one is the Sooner Wekiwa project. And so you can also see, now I'd like to direct your attention to what those areas are in. And so the area where the Wolf Creek line is located is the West Star area is what that stands for. And you can see that the Sooner Wekiwa is located in OKGE area. So it's in Oklahoma is where that project is located. And so what this tells you is that for Kansas, the driver of the economic benefits that I just read out to you is being driven by this line. There's no other projects that are sizable, and there's no other projects that are sizable in the Kansas region. As well as I do know enough about the transmission area of both Oklahoma and Kansas, that those 2 projects, the Sooner Wekiwa and the Wolf Creek, are not that close to each other electrically. And so the benefits that from this portfolio are coming from the Wolf Creek Blackberry line.
Thank you. I don't have any further redirect.
I would have some additional.
Are we doing recross? It's not on
Only
the stage.
only on your questions, if that's permitted.
Chair, you are on mute.
Thank you. Maybe in time I'll pick up on that. It was not our intention to have recrossed. I think we're at an end here. Do any commissioners have any further questions? Seeing none. Ms. Walding, thank you very much for your testimony. It's concluded and you may virtually stand down. Mr. Schulte, we're going to take a break here. I've been advised by some of my closest friends that I should take more frequent 5-minute breaks, and that's what we're going to do. We'll start that probably every hour on the hour from here on. So we're going to take about a 5-minute break. When we resume, if it works for you, we will begin the examination of Mr. Loomis next.
Thank you. That does work.
All right. We'll take a 5-minute break. We will resume here at 2:40. We're off the record. Denise, did that give you enough time?
Yes, thank you. I'm here.
Okay, very good. It's 2:40 and we're back on the record. We're going to resume our examination of witnesses. And I would ask Mr. Schulte, if you would, call your next witness.
We will be calling David Loomis. Apologies, Dr. Loomis. I wanted to make a note for Chair Keen. There was a reference earlier to paragraph 10B of the non-unanimous settlement agreement, which addresses the FERC formula rate filing and the cost containment issues. And there was I apologize for not catching this earlier, but I believe there was a reference to the fact that those questions would be asked of Ms. Finnis, Amanda Finnis.
Right.
And the appropriate witness is actually Ms. Walding. And so if you do want, Ms. Walding is still here and she can respond to a question if you have one on that provision.
Give me a moment.
And I'm sorry, I should have done that before the break and it slipped my mind.
Well, that was actually the first series of questions I intended to ask of Finnis. So we might have Ms. Walding back on the stand for a brief further examination, if we might. Is she there?
Yes, I am here.
Let's see. There you are. Okay. Very good. I think you're muted.
Okay, I'm here.
Okay.
I'm going to show up under Andrew's name right now.
Okay. I did excuse you. Do we need to, I think we need to re-swear the witness because I have excused you. So Denise, if you would, please.
Sure. Please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Yeah, we'll kind of cut to the chase here a little bit, Ms. Walding. Let's turn back again, if we could, to Mr. Harrison's pre-filed testimony, pages 24 through 26.
Do we need to go into confidential session for this portion of the examination?
I do not believe so. I'll let you judge that by my question and by what you think will be the prospective answers. Let me ask the question and then we'll decide that. Tell me when you're there, Ms. Walding.
Okay, almost there. What page of the Harrison testimony?
24 through 26, please.
Okay. I'm almost there.
Okay.
Okay, I am there.
All right. By way of summary, what appears on these pages that's germane to the question I have to ask you are Mr. Harrison's recommended conditions that he believed the commission should impose upon NETE Southwest. And he lists, and we went through some of these in a kind of a little different context. He lists basically about 7 of these. My question to you is very simple. Are the caps and conditions that Mr. Harrison is proposing here, are they analogous? Are they basically the same as all of the caps and conditions that are the subject and the purview of the settlement agreement? You can review those and determine that if you wish.
And so I think you are asking me if all of the provisions that are in Mr. Harrison's testimony are part of the settlement agreement.
Have those in effect been incorporated into the settlement agreement in your judgment? Yes, that's my question.
Okay. I would say the vast majority of them have been. You know, I think the one that starts with first, that is the confidential competitive, was already a part of our conditions of what we proposed in our bid without going into a lot of detail. But yes, that was already a part of our bid. And so it wasn't really a part of the settlement agreement per se.
Okay. Then my second question pertains to Mr. Ives' testimony. If you could turn to that, pages 19 and 21. through 21, pardon me.
Okay.
Again, and my apologies, I don't intend to be repetitious in the least bit, but I will be somewhat general in asking the question and give you some latitude in your answer as well, in fairness to you. We went through some of these specifically and I asked you some direct questions about that. But what I'm going to ask you is basically a question analogous to what I just asked you with respect to Mr. Harrison's testimony. And that is, do the caps and conditions that were proposed by and recommended by Mr. Ives and contained within his testimony, pages 19 through 21, do those mirror or are those roughly the same or the equivalent of the caps and conditions that are contained within the settlement agreement?
Yes, they are roughly the same. Yes.
I know that we dealt with some specificity on number 12 and some of the others, but
let me review them just one more time. And
please do. I don't want you to give an answer that you might feel is an error or incomplete.
Yes, I've reviewed them and roughly they are the same as what we've incorporated in the settlement.
All right. Once again, I appreciate your testimony. Once again, you are excused and you may step down virtually.
Thank you.
Mr. Schulte, if it's appropriate here, if you would care to call your next witness.
Yes, thank you. And sorry for the delay getting to Mr. Loomis, but I do see him.
It worked out.
Yeah, I didn't want you to miss your opportunity to ask a question. So we do have Dr. Loomis on the Zoom. And he is prepared to go under oath and testify.
Denise, if you would, please.
Yes, please raise your right hand. You do solemnly swear the testimony you're about to give and the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Good afternoon, Dr. Loomis. Please state your name and business address for the record.
I can't hear anything.
You have no audio?
You-
Not responding.
Can everyone else hear me?
I can hear you.
Okay, good to go. Mr. Schultz.
Dr. Loomis, please state your name and business address.
My name is David Loomis, and my business address is 2705 Colby Court, Bloomington, Illinois, 61704.
And by whom are you employed and what is your title?
I am president of Strategic Economic Research, LLC, and I'm also professor of economics at Illinois State University.
Are you the same David Loomis who filed direct testimony on February 28th, 2022 and rebuttal testimony on May 27th, 2022?
Yes, I am.
Do you have any additions or corrections to make to your testimony at this time?
I do. I have one small correction to my rebuttal testimony. On page 4, footnote 5, I reference Walding rebuttal testimony at 35:5-8, and that should read Walding direct testimony at 35:5-8.
Thank you for that correction. With the exception of that correction, if I asked you the same questions again today as are provided in your direct and rebuttal testimony, would your answers remain the same?
Yes, they would.
Thank you. I move for the entry upon the record of Dr. Loomis's direct and rebuttal testimony.
Is there any objection? Without objection, they're admitted.
Thank you. The witness is available for commissioner questions and cross-examination.
Very well. Good afternoon, Mr. Loomis.
Good afternoon.
Let's turn to the commissioners first and see if they have any questions or choose to defer. I would start first with Commissioner Duffy.
I defer.
Commissioner French.
I'll also wait until after the parties cross. Thank you.
In this instance, I will as well. We'll turn next to Mr. Zakura.
Mr. Loomis, good afternoon. I am Jim Zakura, representing the retail ratepayers. I'm going to ask you a couple of questions about your testimony, and you correct me if at any point you think I'm not representing you correctly. Now, as I understand your testimony, both direct and rebuttal, you quantify the benefits only on the basis of the entire ITP portfolio of STP, which is, I believe, either 41 or 44 projects. Is that correct?
Could you restate that?
May I ask the reporter to read the question back, please?
Yes. Mr. Loomis, good afternoon. I'm Jim Zakura, representing the retail ratepayers. I'm going to ask you a couple of questions about your testimony, and you correct me if at any point you think I'm not representing you correctly. Now, as I understand your testimony, both direct and rebuttal, you quantify the benefits only on the basis of the entire ITP portfolio of STP, which is, I believe, either 41 or 44 projects. Is that correct?
No, that's not correct. I was quantifying in my testimony the economic impacts solely of the Wolf Creek Blackberry transmission line.
Now, as I understand your testimony, you state, you cite to basically two citations. Number one, you state section 8.2, which shows a 24% rate decrease for Kansas, but this is for the whole portfolio.
So the basis of my economic impact was looking at the construction and operational costs of the line. So my study examined and used those costs on the basis of quantifying the economic benefits.
You're going to have to repeat that statement again. It's unclear to me what your answer was.
I quantified the economic impacts of the transmission line based on the construction and operations costs of that line.
Now, let me ask you about the cost then. I think you note in your testimony, I think you cite to staff, Ms. Becky Walding of NETE Southwest also estimates the impact of the Wolf Creek Blackberry project at 4 cents per month for the average residential users. Do you recall that part of your testimony?
Could you point me to where that is that you're reading from?
I do not have that before me, so may I ask you, is that let me rephrase the question then. What do you believe the impact is for a residential customer of either the portfolio projects as a total or the Wolf Creek to Blackberry line?
So in my report, I quantified the economic impacts in terms of the jobs, the earnings, and the economic output, a measure like gross domestic product that would come as a result of the construction and operation of this line. And that's what was detailed in my report.
Now, when you say construction and operation of the line, Mr. Loomis, are you talking about just the cost of the line and the economic impact related to the costs?
That's correct. That's the construction costs and the operations expenditures.
Did you, in the preparation or in your testimony, Mr. Loomis, did you consider the SPP portfolio of projects and how that would impact the state of Kansas?
I did examine that and reference that in my, I believe it was my rebuttal testimony.
And that is what I was trying to get at in the first instance. And that was, as I understand your testimony, that was a reference to the portfolio projects. Is that correct?
That is correct.
And what was your impact on the portfolio projects overall?
So as I state in my rebuttal testimony on page 4, that both SPP and NETE Southwest have shown that the overall project will result in significant benefits, i.e. from reduced economic generation costs in Kansas to Kansas customers of 24 cents per kilowatt hour, and that those benefits will more than offset the 4 cent per kilowatt hour increase that NETE Southwest estimates will occur from the additional transmission costs from the project.
Now, are those portfolio costs or are those Blackberry, Wolf Creek to Blackberry?
So as was explained at the end of the testimony, this project is, if we look at the portfolio, this project is roughly half of the overall costs or expenditures in that portfolio, and most of the benefits that would accrue to Kansas, of which this is not looking at the portfolio, but it's looking at the portfolio and its benefits to Kansas customers from that would likely flow from this transmission line.
Now that's where we're going to have a further discussion, Mr. Loomis. SPP has not in any fashion undertaken, has it, to isolate the Kansas benefits from the Wolf Creek to Blackberry line. That is an assumption that Ms. Walding is making based on some analysis that she's done, which is not in the record. Is that correct?
I objection. These questions go beyond the testimony of this witness and are better addressed by other witnesses with knowledge of the SPP study.
That is absolutely incorrect. He referred to Ms. Walding's testimony just now. Okay, he recanted Ms. Walding's testimony in the testimony he just gave. And what we are going to go to is whether or not that kind of assumption that was never made by SPP is any kind of a legitimate assumption.
So can I ask counsel for the industrials if he has Dr. Loomis's rebuttal testimony in front of him?
I want him to answer the question that I answered. Pardon me, gentlemen. I was on mute, or I would have interceded earlier. I'll have to somehow, I don't know, become more cognizant of the mute button here. I'm going to overrule the objection. The witness may answer within the scope of his knowledge.
My understanding of the SPP report is that these are benefits of the portfolio to Kansas customers.
Of the entire portfolio, correct?
In the report, that's correct.
And SPP has never tried to isolate Kansas benefits in this case. In fact, they have done just the opposite. They've only done an entire portfolio analysis. Is that correct?
I have no knowledge of what SPP has run or not run, but I can tell you what I relied on in this testimony was the SPP ITP report.
Which was in fact the total portfolio report, correct?
The number that I cited is for the whole portfolio.
Now, let me ask you a question based on your earlier answer, Mr. Loomis. There's 41 projects in the portfolio, and you are saying that simply because one project is, maybe a third or 2/3 of that you can make assumptions as to the savings of the entire portfolio and where they are. Would I be correct that no professional economist would make that assumption without analyzing the entire portfolio? You would never do that based on a ratio to the total.
I believe that based on the information that came from the SPP project, that it is reasonable to look at those benefits that are quantified as coming to Kansas as being attributed to those investments, almost all of which are flowing from this transmission line.
Well, let me ask you this. In arriving at that conclusion, did you analyze portfolio projects 1 through 10 to see what their benefits were?
I'll renew my objection. This witness is not here to testify about the SPP ITP. There are more appropriate witnesses.
It's overruled. Please, I'm going to overrule the objection. The witness may answer to the best of his ability.
No, I did not do an independent analysis of projects. I think you asked about 1 through 10. I did not do an independent analysis.
So you don't know what the benefits of those, any of those would be, do you?
I do based on what's in the SPP report.
But that would be the total portfolio savings, correct?
That would be the total portfolio savings, yes.
And any attribution or estimate that you might make of Wolf Creek has never been made by SPP, is that correct?
I do not know. You would have to ask SPP.
In any of the items that you've read about the ITP portfolio, have they isolated the benefits of any one of the 41 projects?
We have I'm sorry, but we need to get through witnesses today in a timely fashion. And
that's not an objection. That is not an objection. That is simply you're wanting this witness not to answer the question. I'm entitled to ask the question.
Gentlemen, please. To the extent there was an objection, I'm going to overrule it. The witness may answer within the scope of his knowledge.
Could you repeat the question?
Yes. To your knowledge, based on your review of the ITP portfolio of 41 projects, SPP has not made any individual attribution of benefits for any one of those projects.
Again, I don't know what SPP has or has not done, but I did rely on the SPP ITP report.
And there are no individual benefits associated to any one of the 41, Arthur.
They look at the portfolio as a whole. That is correct.
Thank you. Let me, Mr. Loomis, please ask you to turn to, it's in the public part of your testimony, the executive summary. And it is page 6 of 37, sir.
Okay, I'm at the executive summary.
Now, if you go down to about the middle, you see a tab titled Jobs. Do you see that?
Yes.
Now, on the second bullet point, it says approximately 6 new long-term jobs for the state of Kansas for the first 10 years. Do you see that?
Yes.
Is that 6 jobs per year, or is that 6 jobs in 10 years?
That is 6 jobs lasting for the first 10 years of the project.
Let me ask the question a little bit differently because I still don't understand your answer. Are you talking about 6 jobs per year for 10 years?
Yes.
Let me ask you to go to the next bullet point. You say approximately 9.6 long-term jobs for the state of Kansas after the first 10 years. Is that 9 jobs per year for years 11 on?
Yeah, that's per year.
Now, go to worker earnings, if you would, please, in the second bullet point. And I'm going to try to equate this with what you say above on the jobs. On the second bullet point, you say 498,000 in long-term earnings for the state of Kansas for 10 years. Is that 498,000 per year, or is that 498,000 earnings over 10 years?
That is per year.
Okay. And so what you're saying is there's 6 jobs and $500,000 basically of new economic impact in Kansas because of that line, the Blackberry line. Is that correct?
$498,000 of earnings.
Each year?
Annually, yes.
Now, on the third bullet point, it's 716,000 in long-term earnings after the first 10 years. Is that correct?
Correct.
So that would be 716,000 divided by the 9.6 new long-term jobs. Is that correct?
Why are you dividing those two numbers?
Well, I'm trying to figure out what the annual raise would be, or what the annual salary would be for those particular workers.
Yes,
For
you
the-
could get average earnings per worker by dividing that through.
So I would be correct in saying, let's look at the more up to the top of your executive summary, if I could. The project, in the third paragraph, you say the project represents an investment of over 85 million in total, 74.6 million estimated to be spent in Kansas. Do you see that?
Yes.
So initially, so what it would seem that your testimony would be is that the economic impact is for the construction of the pipeline, and it doesn't have an extended economic impact other than the jobs and worker earnings that you and I spoke of.
There would also be property taxes that are detailed in the report.
And the property taxes are not due until after the first 10 years. Is that correct?
That's correct.
Chair Keen, thank you. I have nothing further. Thank you.
Thank you, Mr. Zakir. Mr. Kimmel, any questions for this witness?
No, Commissioner.
All right. Let's double back here and see if we have any questions at this point from the commission. Turn first to Commissioner French.
Thank you. Good afternoon, Mr. Loomis. I was taking a look at your rebuttal testimony, page 4, and the only question I have is really a clarification. I'm looking at the question that begins at line 6, but I'm really looking down at lines 12 and 13 on page 4. Are you there?
Yes.
Those sort of lay out what the costs and benefits of the 29 ITP package are for Kansas customers. The benefits as represented in your testimony, which I think you took from Ms. Walding's testimony. It says here 24 cents per kilowatt hour, and it says the costs are 4 cents per kilowatt hour. I think average electric rates in Kansas are around 10 cents. So I just want to confirm that's actually megawatt hour, not kilowatt hour for both of those numbers, correct?
I would have to go back and check that, but yeah, that does make sense to me.
It could substantially change our analysis if that's kilowatt hour, but that may be something I follow up with others on, but I think we need to lock down exactly what we're talking about. And I guess for the record, I did go back and check Ms. Walding's references to the ITP, and I believe I could represent its megawatt hours. Just wanted to make that clarification if possible. So anything to add, Mr. Loomis?
No.
Okay. That is really the only thing I had for this witness. Thank you, Chair Keen.
Thank you, Commissioner French. Commissioner Duffy, any questions of the witness?
Yes, please. Thank you. Dr. Loomis, I'm back on your executive summary page, page 1, and actually I'm in the same section that Mr. Zakura was. So following along that paragraph that begins, the project represents. So in the second line, it states, and an additional approximately $10.1 million in substation upgrades in Kansas by others. So can you just wrap a little narrative around that last part?
Yeah, the numbers that I received from NETE Southwest broke the cost of the project into 2 parts. One was the cost of the transmission line that they would be responsible for and building, and the other was upgrades that they are not paying for, but that were going to be required as part of the overall project. And so we separated out those two effects so as to not attribute the total project to payments by NETE Southwest. And those are specific to, I believe it was Coffee County, that in one specific spot where those substation upgrades are going to take place.
Okay, but by others, do you know who you're referring to?
I'm not entirely sure.
What company that would be, or companies?
No, I don't think I was directly told when those cost estimates were given to me who would be making those expenditures.
Okay, so somebody else might be able to speak to that as to what the 10 million, who would be expending those dollars for the upgrades. Okay, thank you, Dr. Loomis, and that's all I have, Chair Keen.
Thank you, Commissioner Duffy. Dr. Loomis, I have no questions for you. Mr. Schulte, if you care to redirect.
Thank you. Dr. Loomis, you were asked several questions by Mr. Zakora and Commissioner French regarding page 4 of your rebuttal testimony. And I would direct you to the question there at line 6. What was the purpose of this portion of your rebuttal testimony? What were you rebutting?
I was rebutting the claim that I only looked at part of the economic costs and benefits, and that I only looked at one side of the equation, and that I didn't take into account negative economic impacts that Dr. Macholm claimed were there due to rate increases that would be coming as a result of the project.
Okay, and so is it accurate to summarize it as, well, you were relying on others for what the rate impact would be? Is that accurate?
Yes, I was looking at other filed testimony, the SPP ITP report, and also staff's staff's report that was filed, and their conclusion to come to the conclusion that there would be no negative or rate increases that would negatively affect the economic impacts.
Okay, thank you. I don't have any further redirect.
Very well. Any commissioner questions further? Seeing none, Mr. Loomis, I believe we've reached the end of your testimony. You may step down and you are excused. We appreciate your testimony. Thank you very much.
Thank you very much.
All right, Mr. Schulte, if you would, call your next witness.
Yes, and I'm going to be handing over the duties to my colleague Ann Kallenbach, and I will step aside and let her call the next witness.
Very well.
And we may need just a brief recess just to play a little musical chairs here. It won't take long.
Make it a short melody.
Okay. That should go in her laptop, right?
Yeah.
Okay, so then how would we mute if we need to mute?
It'll be that red button.
Okay, so I'll have to stand up.
I'll close my account. And that, you have some windows open that would be helpful for you.
What's that?
There's all the folders of testimony.
Okay, great.
Mr. Schulte. This is Jared Jones from KCC. You guys are off mute at this time.
Thank you.
Well, we've got a minute. Denise, we might be going late tonight. How late would you be available to work today and possibly tomorrow?
That shouldn't be a problem for me.
Okay.
We're having a little technical difficulties getting the witness on the Zoom.
Okay, what I think we'll do, we're going to take, jump the gun a little bit on our next break. It's now 3:22. Let's take a brief break. We'll resume at 3:30. And we will go off the record at this time and resume at 3:30.
Good afternoon. This is Lamargo Sweezer Fisher at NextEra Energy Transmission, just doing a sound check.
Good afternoon. I'm hearing you fine. Thank you.
Thank you very much.
Hi, Michelle. It's Ian Collenbach. I'm doing a sound check as well. Can you hear me?
Yes, I can. Thank you.
Okay, thank you.
Okay, Michelle, if we could go back. Very good. Denise, are you set?
Yes, I'm ready. Thank you.
Yes, very well. It's 3:32 and we're back on the record again. Ms. Collins, are you able to get situated?
Yes, I believe so. Thank you, Chair.
Being a lot of feedback on my mic here. Michelle, can you hear me?
Yes, I'm here. Yes, I'm hearing you.
Is the feedback gone?
Yes, it is.
Okay. Very well. Ms. Kallenbach, if you would, call your next witness.
Yes, thank you. NextEra calls Lamargo Sweezer Fisher.
Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God?
I do.
Thank you.
Would you please state your name and business address, please?
My name is Lamargo Sweezer Fisher, and my business address is 15430 Endeavor Drive in Jupiter, Florida.
And by whom are you employed and what is your title?
I'm employed by NextEra Energy Transmission as the Senior Director of Operations.
Are you the same Lamargo Sweezer Fisher who filed direct and rebuttal testimony on February 28th and May 27th, 2022, respectively?
I am.
Do you have any additions or corrections to make to your testimony at this time?
I don't have any additions or corrections to my testimony.
If I asked you the same questions again today, would your answers remain the same?
They would remain the same.
Thank you. This time I'd move the commission to enter both portions of Ms. Sweezer Fisher's testimony into the record.
Is there any objection? Without objection, they're admitted.
Thank you. I have no further questions and will tender the witness for cross-examination.
All right, thank you. Ms. Sweezer Fisher, good afternoon.
Good afternoon.
Let's turn first and see if we have any commissioner questions for you on cross. I'll begin first with Commissioner French.
No questions. I'll reserve any questions till after cross. Thank you.
Thank you. Commissioner Duffy.
I'll reserve questions till after cross. Thank you.
Thank you. And I will do the same as well. Mr. Zakura, any questions for this witness?
Thank you. Thank you. I'll have very few questions. Good afternoon.
Good afternoon.
I just have a few questions about operations, and they have to do also with the number of permanent jobs that Dr. Loomis just spoke of. May I please ask, is it the intent of NextEra to hire and retain employees in Kansas if they are permitted to construct and operate the BlackBerry line? Will you have a operations office in Kansas?
We will have an operations office in Kansas.
And would you be able to state, or could you please state, how many employees you expect to have at that office?
We expect to have 2 employees employed at that office.
I did not quite hear you, ma'am. Did you say 2?
I did.
Okay. And what would those 2 employees do at the office? I mean, what would those employees' job responsibilities be?
So the 2 positions would be responsible for the overall project management, operations and maintenance of the assets there in the state of Kansas. We plan to employ an engineer, and we also plan to employ a high voltage leader.
May I ask a couple of further questions? When you speak of those employees, are those employees to be employed during construction, or would that be after construction?
Those employees would be employed closer. It would actually be during construction as we lead up to the transition to operations. There are some activities that we would expect those employees to perform to ensure that the assets, the facilities themselves are built and ready for operations.
In addition to the 2 employees that you speak of, will there be other divisions or employees assigned to manage or supervise the Kansas operations?
There are other employees, as I referred to in my testimony, that we will be utilizing as part of support resources for the Wolf Creek to BlackBerry project. Those employees are of NextEra Energy Transmission affiliates and perform similar duties for facilities that have a similar function in the state of Kansas.
I guess the final question, please, I would have for you is, are the 2 employees that you're speaking of that will be Kansas employees be in addition to those employees that were identified as full-time employees by Dr. Loomis?
I'm not clear what was included in Dr. Loomis's estimate with regard to that. I do know that those two employees would be incremental to the existing employees that we have employed in the state of Kansas.
Thank you very much. Chair Keen, I have nothing further.
Chair King, you're on mute.
My apologies, my apologies. Mr. Kimmel, any questions of this witness?
No questions, Commissioner.
Thank you. Let's see if there are any commissioner questions at this point. I'll turn first to Commissioner Duffy.
Yes, you could answer the question that I had asked of the previous witness about the $10.1 million in substation upgrades that are related to this project. Who are the others?
So I am not familiar with the $10 million of substation upgrades. However, with regard to the project, we cover the transmission line only.
Okay, thank you. I will just continue to ask that question. All right, appreciate it. That's all, Chair Keen.
Thank you. Commissioner French, any questions of this witness?
I have no questions. Thank you.
I have none either. Given that eventuality, I think Ms. Callenbach will turn to you for any redirect you may wish to have.
We have no redirect. Thank you.
All right. Well, Ms. Fisher, we appreciate your appearing here this afternoon. Your testimony is at an end and you are excused. You may step down virtually.
Thank you very much.
Ms. Callenbach, if you would, call your next witness.
You are muted.
Ms. Callenbach, you're muted.
Oh.
Call your next witness if you would.
Well, it was coming through Ms. Sweezer Fisher's sound previously, so I think maybe you'll need to switch it to your own.
A technical glitch here.
Yes, apologies. Can you hear me now?
Yes.
I can hear you now. If you would, please call your next witness.
Yes, sir. NextEra calls Daniel Mayers. We might need 1 minute to reshuffle our witnesses, please.
Okay.
He has connected to the meeting.
I'm not seeing Mr. Mayor on my screen.
Chair Keen, one moment, please.
Mr. Mayor, I can see your boxes there now. Do you have audio?
Okay, please raise your right hand, sir. You do solemnly swear the testimony you're about to give in the matter now in hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
We didn't get any sound from you, Mr. Myers. Myers.
Sorry, one moment.
He is unmuted, but no sound came through.
Right. I think they're working on it.
Chairman Keen, I believe we're ready to proceed. Thank you.
All right. Mr. Mayor, I'm not sure that I think you were administered the oath. I'm not sure we heard your response.
I do.
Am I correct there, Denise? Had you administered the oath?
Yes, I did. Thank you for clarifying
Okay,
that.
we have the response now. Very good. Ms. Kallenbach, please continue.
Thank you. Would you please state your name and business address, please?
My name is Daniel Mayers. My business address is 700 Universe Boulevard, Juno Beach, Florida.
And by whom are you employed and what is your job title?
I am employed by NextEra Energy Resources, and my title is Director Transmission Substation Engineering.
Are you the same Daniel Mayers who filed direct and rebuttal testimony on February 28th, 2022 and May 27, 2022 respectively?
I am.
Do you have any additions or corrections to make to your testimony at this time?
I do.
Would you please go through that?
Yes. On my direct testimony, on page 8. That's my indirect. On line 9 of my direct testimony, the mileage that shows 231 is actually 229.3. And in my rebuttal testimony, it's the same adjustment needs to be made. And that is on page I will find it. I'm sorry, Chair. It was on my direct testimony, page 25, line 11. Same number, 231 changes to 229.3.
Thank you. If I asked you the same questions again today with that correction, would your answers remain the same?
Yes, they would.
Thank you. At this time, I would move the admission of both the direct and rebuttal testimony of Daniel Mayers.
Is there any objection? Without objection, it's admitted.
Thank you. I have no further questions and will tender the witness for cross.
All right. Good afternoon, Mr. Mayor.
Good afternoon.
Let's turn first to the commissioners, see if they have questions or would prefer to defer. I'll begin first with Commissioner Duffy.
At this point, I will defer. Thank you.
Thank you. Commissioner French.
No questions. Thank you.
All right. Mr. Mayers, I do have a few questions for you. Let's take a look at the settlement agreement, page 11. Tell me when you have it.
I'm there.
All right, bear with me 1 second. Take a look at paragraph E, if you would. As in echo, E.
Yes, sir. I'm there.
It's a short one sentence paragraph. I'll read it into the record. It says, NETE Southwest will construct the Wolf Creek Blackberry project consistent with SPP's design criteria contained in the SPP RFP and consistent with the construction specifications in the NETE Southwest bid. Have I accurately read that provision of the settlement agreement?
Yes, you have.
Here's my question. So there's a commitment here to construct the Wolf Creek to Blackberry line consistent with the SPP designated criteria contained in their RFP. Does that include, in your judgment, using spun concrete poles?
Yes, I do believe that is that can be considered. Yes.
So that is what is intended. Is it that in constructing this line, spun concrete poles will be utilized? Is that correct?
Predominantly. Based predominantly, sir. Based on today's proposed route, we have approximately 545 poles for the project. Of that, approximately 480, give or take a few, are expected to be concrete, with the balance being steel.
Okay. Have you read the testimony of Kelly Harrison, who's provided pre-filed testimony on behalf of Evergy?
Yes, sir, I have.
Let's take a look at that now, if we might. Let's start with pages 5 and 6. Tell me when you're there.
I'm there.
All right. In connection with the operation of electric transmission lines, can you describe for the record and for me what is galloping? What's meant by that?
Well, galloping is a phenomenon that occurs generally in the winter months, late fall, winter months, when you have a combination of snow and or ice that begins to settle on the transmission conductors, and you get a perpendicular wind of approximately above 15 miles an hour that hits the conductor, and it begins to create, it's almost like an airfoil. The ice settles on one side of the conductor, and as the wind blows across that conductor, it begins creating an amplitude that you begin to notice in the conductor. So as I want to call it galloping because you're going up and down, it's basically an increase in the amplitude on the conductor.
Okay. When it's operational, is it a reliability concern?
It can be. There's no doubt that, we do our best to engineer into the design. Specifically in this case, I cited in my testimony multiple ways to try to mitigate the problem. In this case, we look at increasing phase spacing between the conductors. That would prevent what some people refer to as line slaps. There's also the use of weighted pendulums. There's separators that you can put in between phases to prevent them from actually slapping. There are multiple mitigation techniques, but there's no one catch-all. There's no one specific answer in each particular case. So you have to study these. And we study these with some of our outside vendors. And a determination is generally made as to what the best mitigation case may be for the particular application.
Okay. Take a look with me, if you would, at page 5 of Mr. Harrison's testimony. Let's turn first to lines 17 through 19.
I'm there.
All right, I'm going to read it into the record. Beginning at line 17, it says, well, beginning at line 16, the question is, what other reliability concerns do you have, question mark? And the answer beginning on line 17 is, quote, per its response to KCC-3, attached as exhibit KBH-3, NETE SW has had numerous outages on lines it operates in Kansas over the last several years, specifically outages on generator leads in the Kingman area due to line galloping. The testimony of Mr. Harrison continues on lines 20 through 23. 20 is the question, why is this concerning? The answer is, beginning on line 21, I have driven by the Kingman area generator lead lines many times and can confirm the lines are constructed of spun concrete poles using down guys, which is a similar type of construction that NETE South SW plans to use on the proposed WC-BB345 kW line. Have I accurately portrayed what is Mr. Harrison's testimony?
Yes, you have.
What is your response to these concerns?
Well, I disagree with them. First off, the pole type doesn't matter. It has nothing to do with whether it's a concrete pole or a steel pole or a lattice tower or even wood. Line galloping happens all over this country, specifically in the northern climates where you have a combination of the ice and snow conditions that I mentioned earlier. So it has nothing to do with whether it's a concrete pole or not. As far as the issues specific to the Kingman area, I'm not the operations witness in this case. I am familiar that there are studies that are underway. The outcome of those studies is also being, well, the consideration of the studies themselves that are being undertaken are being considered as part of our response to the mitigation on the Wolf Creek to Blackberry 345 kV line. But we believe we'll be able to mitigate this, and we believe that we'll be able to eliminate any reliability concerns that the KCC has.
Let's turn to page 6 of Mr. Harrison's testimony. Drawing your attention to lines 17 and 18. Tell me when you're there.
I'm there.
I'll start with 16, which was the question of Mr. Harrison. The question is, why is this a concern? And it has to do with reliability, which was asked in the previous question. The answer is down guys present a failure waiting to happen. And when one fails, it typically causes an outage to the line and possibly damage and or harm to the public. Continues on line 18, a large portion of the route that NETE SW has proposed crosses an area consisting of farmland and ranch land. Using structures with down guys creates an obstacle or hazard for farmers. I've ended that quote on line 20. Have I accurately reflected what appears in Mr. Harrison's testimony?
You have.
Why does NETE Southwest use down guys? If you do.
Yes, we do. We don't, well, so again, back to the total number of structures on this line, there are 545 as per the proposed route. And of that, we only have approximately 9%, or I think roughly 43 structures that are going to be guide. The rest of them are unguided structures. So first off, it's a small percentage. While I understand that there are concerns with guys, whether they're in ranch lands or in row crop fields, we will continue, and we are, as we lay out this line, we continue to work on finding means and methods to eliminate the guying that we can, or move the guying so that it doesn't obstruct both farming and or the any of the ranchers' concerns. But in general, we're very confident in use of guide structures. We've been using guide structures all over the US. We use guide structures where necessary. It helps reduce the capacity of the poles and reduce the cost of those poles. Guide structures are used here in Florida. And, we see a lot of the same weather conditions. We don't get the cold weather that Kansas gets, but we get hurricanes and we get tornadoes. And these structure types have held up very well, including the guide structures. So we have a high level of confidence, and with the experience that we've had over the years, both not just with Florida Power and Light here in Florida, but all over the country in the use of guide structures, that they are another tool in the toolbox to help us keep our costs down and yet ensure the reliability of the transmission line.
Under what circumstances, if any, would you opt to use self-supporting structures in lieu of down guy structures?
Generally as a last resort because of the cost. Self-supporting structures, if you're required to put a deep caisson type foundation in the ground, these caisson foundations can be 8 to 10 feet wide, 40 to 50 feet deep, depending on soil conditions. You add a rebar cage on top of that, and then you add the cost of the steel tower on top of that, and you could have very expensive structures. So we tend not to use them where we can, but if there's no other choice, we will go ahead and use them. Specifically, we've agreed to dead end our structures on either side of Evergy's lines. That doesn't mean they're going to be concrete encased lines, but it does mean that we're installing dead ends. And just in general, there are cases where we might be required either through a county road requirement or some type of permit, whether it be federal, state, or local, that might require us to not use guys for some reason. And therefore, we would be forced to use either a self-supported steel structure or equivalent.
All right. Turn with me, if you would, to page 8 of Mr. Harrison's testimony.
We're there.
Draw your attention to lines 4 through 7. I'll read it into the record. Line 4 is a question. It is, what is your recommendation for the use of guys? That is the recommendation of Mr. Harrison, who is the person whose testimony I'm reading here. His answer beginning on line 5 through 7 is, the proposed WC-BB 345 kV line should use as few down guy structures as possible. If they are used at all, it should be used in open grassland used for grazing. This type of terrain should result in low risk of down guy failures from equipment or vehicles. Your reaction or response to that, Mr. Mayor?
Well, I agree. That's what he has stated. I don't agree that we should be limited to the use of down guys in only grassland. I don't see, as I mentioned, we're working with landowners to move guy structures as close as we can to the edge of their fields. In some cases, there are spots that I've seen along the route where we have open areas that are not currently farmed on certain landowners that would be applicable for guide structures. I think in terms of his repeated mention of guy failures, guys don't fail very often. I know there was one, I think there was one example cited where a guy was hit by either a combine or a piece of equipment. Yeah, those are going to happen. But we basically we mark the guys, we mark the anchors. We talk to the landowners to ask them to maintain a certain distance around it so that it is safe for not just them and their equipment, but for the reliability of the line.
All right, thank you. In constructing electric transmission lines, what are the most likely construction problems or obstacles that create the potential for cost overruns?
Delays. Delays in acquiring the land in a timely manner, delays in obtaining permits in a timely manner. And specifically, once a job is under construction, any delays to the contractor. Once the contractor is out on site and potentially with a line of this size, you could have upwards of 100 people on a crew doing various or hundreds doing various phases of the line work. You don't want them shut down for any particular reason. In addition, because we're interconnecting at 2 points at both Wolf Creek and Blackberry, the timely completion of the system upgrade work that's required. If it's not completed in a timely manner, then we could also see delays. And anytime you delay a project, the potential is there for costs to go up.
Weather-related issues, could that contribute?
Sorry, sir. Could you repeat?
I say weather-related issues, would that contribute?
Yeah, absolutely. Weather can be a factor. Look, there's definitely other reasons. I tried to cite some of the bigger concerns, but sure, we could work. You can have rain days. You can have heavy snow days where you just can't get access to properties. But I will say, we've recently completed a line in northern Ontario that we worked round the clock, roughly 10.5 months per year, including the winter, to complete. So the contractors that we work with, they're used to having to work in heavy weather type conditions. And I think we're well set up for completing this work in a timely manner, provided we get all, again, our permits on time, and we get I say good weather. There's weather days built into schedules. There's some buffer that's generally built in. The contractor knows he's not going to be able to work every day of the week, or at least 6 or 7 days. 5 or 6 days a week. But in general, we feel like we're well experienced at this, and we'll be able to complete this project on time.
My final question takes us back to the settlement agreement. If you could go to page 11 of that, please. Tell me when you're there.
I'm there.
All right, let's take a look at D, paragraph D. And I'll read into the record what paragraph D states. It states that NETE Southwest will consider and address as part of its line siting proceeding an option to double circuit a 25-mile portion of the Wolf Creek - Blackberry project that parallels an existing Evergy 161 kV transmission line, subject to receiving necessary approvals for a change in project scope from SPP and necessary agreements from Evergy. Can you envision any circumstances that would preclude you from proceeding with this double circuit approach?
I think, as stated in D, we need SPP to go back and review from a planning perspective. I'm not a planner, so I can't. I think their witness would be better to discuss that. But now that you have 2 circuits on a single structure, there's the potential, if you did lose a structure, that you have 2 lines down. So there may be transmission system impacts that would need to be considered. So I would expect SPP to want to weigh in on that. As noted there as well, Evergy, it's not very often that you find a single pole that has multiple ownership on it, on a transmission line. I won't say it has been done. We have done it in the past. But it's generally a very difficult negotiation because we're two different operating companies. We do things differently. Our design criteria may be different. Our operating, the way we operate the system may be different. So getting to that agreement with Evergy and doing it all in a timely manner based on the schedule that we have concerns me.
If you've said about doing this, assuming that you get the approval from the change of scope from SPP, will this entail added costs for the project?
It depends. And that's a general engineering answer. It will depend. So if we started by whether there was a cost share agreement versus the cost was beholden upon the NextEra NETE Southwest. And what I mean by that is if you said to go ahead and build this line and we worked through with Evergy on an agreement and we came to some agreement, would we be the responsible party to build that line? And would that cost be borne by us or would it be a shared cost agreement? The fact that you're, in this case, for us, let's say, let's just use a hypothetical that if you said that we would bear all the costs and then we would work out some agreement at some later date, that cost would definitely go up because now I'm responsible for redesigning my structures. So I have engineering costs because I now have a second set of conductors and another line that I have to deal with. I've got more insulators. I've got more cross arms. I've got the labor to do all that work. There's no doubt that the cost would go up if indeed we bore all of the cost for that. If there was some shared agreement, then there is the possibility that we could, do the work and somehow find a means to agree on a design criteria that could keep costs lower.
I appreciate the detailed nature of your responses to my question, Mr. Mayor, very much. I do have another question now, but that response kind of provoked it. This 161 kV line of Evergy is in existence right now, is it not?
Yes, it is.
I'm going to just kind of rely on your engineering skill, your knowledge, and your experience. In considering the specs and the various aspects of this particular undertaking, since you have to go back to SPP for approval for a change in the scope, for what? Why would SPP not take into consideration the fact that this might be a problem when they evaluated all the bids? Have any idea? Just based upon your experience.
Yes, sir. I'd rather not speculate on what SPP thinks about this at this time.
Kind of hard for me to believe. I'll just make one editorial comment and go on. That line's kind of the elephant on the table. It was there. Kind of makes me wonder why. I'll ask that questions of others. Mr. Mayers, I appreciate your indulgence of my questions. Let's move on. I'll turn next to Mr. Zakura. Do you have any questions of this witness?
Yeah, I have just a few. Good afternoon, Mr. Mayers.
Good afternoon.
There has been there has been some discussion in this case about the project that NextEra, I guess, is currently still undertaking in the state of New York. And perhaps the costs went up over the projected costs. Are you the proper person that would be able to explain that and give some context to that case?
No, I believe Ms. Waldings responded to that in her testimony.
Let me ask another question then. Are you the appropriate person, Mr. Mayers, to address the issue of the final costs of the project? Or is that more appropriately deferred to Amanda Fennis?
Can you define the project?
Certainly. Well, let me give it some context, sir, and see if I can be helpful there.
I'm sorry, I only said that because you just mentioned New York and I wasn't sure if you were coming back to Wolf Creek Blackberry or you were staying on the same subject.
I apologize, sir. I was not as clear as I could be. I was back on the Blackberry project, sir. Okay. Are you the appropriate person to talk about final costs of the project, or would that be Ms. Fennis or Amanda Fennis?
I don't know how we can define final costs at this point, considering we haven't even started really working our way through the project. So I'm definitely not in a position to answer any questions related to final costs.
Okay, let me rephrase the question. I apologize for not being as clear as I should be. I believe in the testimony of Ms. Fennis, she speaks of costs of $85.2 million in 2020 or 2022 dollars. I was trying to go from that point as to what the in-service costs are likely to be in 2025 if the project is approved.
Yeah, I'm sorry, I can't speculate on that at this time.
Chair Keen, thank you. I have nothing further. Thank you.
All right, thank you, Mr. Zakira. Mr. Kimmel, any questions of this witness?
No questions, Commissioner.
Thank you. Let's see if we have any follow-up questions by my fellow commissioners. I'll begin this time with Commissioner French.
No questions. Thank you.
Commissioner Duffy.
Thank you, Chair Keen. Good afternoon.
Good afternoon.
Mr. Mayor. So I'm going to ask this question of you. Maybe you're the one to answer. Based on the Loomis executive summary, there is a line that talks about the additional approximately $10.1 million in substation upgrades in Kansas by others. Can you share any information on that, please?
I hope so. I think what we're referring to here is the work that needs to be completed at both Wolf Creek and the Blackberry substations.
Okay, so the work that needs to be completed at Wolf Creek, this was prior to the condition of moving the interconnection outside and off the boundary, the property boundary.
Yes, that's correct.
Okay. All right. And the Blackberry has to do with the connection actually to the Blackberry facility, correct?
Yes, that's correct.
Okay. Other than that, there's nobody else involved here.
Not that I'm aware of, ma'am.
Okay. All right. Thank you. I do have a second question. I've had the opportunity and the pleasure to do camping and canoeing and traveling in the southeast part of the state. It's really very lovely and very lush. And the topography is so different than being raised in Wichita, where it's all pretty flat. You go from rolling hills to forests to grassland to cropland. So as I look at the route crossing through the 5 counties, are there any exceptional, and I know this isn't a sighting, but since I have you here, anything exceptional? Also, there's a lot of oil and gas in that area, a lot of wells. So anything exceptional that was encountered?
No, not that I'm aware of. in my line of work, working in 38 different states, 4 provinces in Canada, we see all different types of topography, from mountains to deserts, to the prairie, to, the grasslands, to the swamps in Florida. And we've seen it all. I'm very comfortable that when we come to an agreement on the route, that we'll be able to build this line under all the conditions that, we'll have to live with as far as environmental and topographical type issues that we have to contend with. But no, there's nothing really special about it. I understand it. It's beautiful land. We deal with a lot of beautiful land. We deal with a lot of really ugly land. And at the end of the day, we take a really hard look at how the work needs to be done, and we make a determination of the impacts and factor all that into our costs. And at the end of the day, there's nothing about this particular section in the Southeast that gives me pause.
Okay, thank you. Next question. Already this year, Kansas has experienced significant wind days, and I'm not talking about the tornadoes. I'm talking about severe blowing winds where they actually call it a significant wind day. We've had more in the first 5 months than we had in the whole of calendar year 21. So there's, I think, that issue, whether it stays this way, don't know, but that brings with it the increased fire danger. And I don't think anybody could have anticipated the severity of the fire, the Four Corners fire in Hutchinson. I happened to be driving through and that area of the country, and my jaw was dropped. It was so disheartening to see what occurred. And this isn't our first. I mean, it was significant. A lot of buildings, a lot of fencing, outbuildings. And so as we look at our climate change here in Kansas, and we're experiencing things that we did not have before, has your company, are you aware of the changing dynamics in this state? And are you preparing anything that would help to counterbalance what's going on? I understand even in Southeast Kansas, they have not had the rains. Now, maybe that's changed in the last week, but the rains that they normally get during the early spring.
So let me make sure I clearly understand what your ask is. You're asking me whether we take into consideration in our design the climate change that's occurring in Kansas. What I can tell you is we meet all the requirements of the National Electric Safety Code, as well as the specific requirements that SPP set for us. We're also obligated to meet any federal, state, and county or local requirements. But we are designing this line to meet the National Electric Safety Code requirements. And we understand that there are concerns about farming. We have taken that into consideration by adjusting clearances on our structures, which keeps the conductors higher up. Now, this is, in my personal opinion, this is a great opportunity for us to sell the concrete pole. We believe in the concrete pole. We believe in its resiliency, its strength. If part of what you're driving towards is concerns about fires being caused by transmission lines, or at least being started by transmission lines, we're well aware of the work that's been going on, or not the work, but the problems that California has seen, for instance. We have assets in California, and we have wildfire mitigation plans in place. We'll have a mitigation plan that will be driven towards not only the safety of our workforce because, you know, let's just say they're stuck in a grassland that as a fire that's coming on. You know, we have notification protocols in place. We have our crews are trained to, when they're working in high wind conditions, to either stop work depending on how hard the wind is blowing. There's going to be county ordinances affected by the building of this line. Someone may say it's a high wind day. We're not going up in buckets. We're not going to do any welding. Let's just say we had some welding or something that would start potentially a fire. And if we did have any of that type of work in progress, we would have the appropriate fire equipment there. And I'm not talking about fire trucks or anything. I'm just talking about extinguishers, spades available to overturn soil. We've looked at all of this in some of the drier regions of the West. We built in Oregon, we built in Washington, we built in California. So we are very familiar with that environment and the changes they're seeing there. And we've taken the appropriate steps ourselves to ensure that our crews are safe and that we're protecting landowner property at the same time.
Thank you. One more question. As you mentioned your crews and the folks you have on the ground, do you typically bring in crews from other states, or do you begin to hire locally?
So that's dependent. As we stated in our submittal, we've been working with Brink, the contractor Brink. They're a non-union contractor. Generally, what they'll do is they'll have specific project managers that may come in from outside the state, and they'll, depending on the work they need to get done. So if they're responsible for clearing, they'll probably hire someone local to do that clearing work. If there's culvert work or road work that needs to be addressed, access work that needs to be addressed, all of those things will generally be done by local contractors. As far as the actual crews, I can't answer that, to be honest with you. I don't know whether there are specific crews that they have in the state today that they would assign to this project. But there's various phases of the project. Whether you're pole setting or whether you're wire pulling, you have different crews. So depending on who's available at the time, a determination will be made as to who's the best crew to actually get on board, and whether they're Kansans or whether they're from outside the state. I wish I could answer that, but I cannot at this time.
Okay, thank you. And thank you, Chair King.
All right, thank you. Mr. Mears, I have a follow-up question prompted by some of the questions by Commissioner Duffy. My question is this: in your opinion, going back to this concrete pole issue again, in your opinion, to what extent did the proposed use of spun concrete poles contribute to the lower SPP bid submitted by NextEra versus the other bidders for this project?
I'm not sure. I won't say significant, but in my experience, we bid a lot of projects. We do a lot of competitive work, whether it's specific to NextEra energy transmission or whether it's building our own wind and solar facilities. So we're always looking to get our costs lower. We've been using concrete poles in Florida for almost 40 years now, and the technology has gotten better. The process for ensuring that we get timely fabrication and delivery of these poles is improved. As I stated in my testimony, there's 2 facilities that can be used. One's in Texas and a brand new one that was just built in Bristol, Indiana. So concrete poles are moving further and further north. We believe that the combination of the concrete pole with brace post insulators has helped us reduce costs on a number of projects. And so that's why we have we bid it into this project.
The reason I asked that is because I'm kind of leaning on your experience pretty heavily here once again. not knowing a fraction that you do about the construction of electric transmission lines, it would strike me that when you try to identify the largest significant capital outlay expenditures that you're going to have in constructing that line, not only the lines themselves, but the supporting structures, which would be these spun concrete poles, would constitute major portions of those of the total expenditure on materials. I'm surmising. Is that pretty close?
Yeah, in general, you can say, and this is a generality, take it for what it's worth, but approximately 50% of the cost of a transmission line is labor, and the other 50% is materials. So yes, the concrete pole is a portion of that overall cost, but labor in general is primarily one of the biggest costs you have to deal with, because of your crew sizes and the timing and the amount of work that needs to get done in a relatively short period of time, considering the length of this line.
All right. Well, thank you very much. I appreciate your responses to my questions as well. I believe this concludes the cross-examination. I will turn back to you, Ms. Collenbach. To the extent you wish to have it, you may have redirect.
Thank you, Chair Keen. We have no redirect.
All right. Very well. Mr. Mayers, I believe your testimony has reached its conclusion. We appreciate your testimony with us this afternoon. You are excused and dismissed, and you may virtually step down. Thank you.
Thank you, Chair Key.
Again, by my reckoning, under my new break policy, we are at roughly 1 hour since the last break. So we're going to take another 5-minute break. At this time, we will recess. I've got straight up 4:30. We'll recess until 4:35. We are in recess.
Butthead. What?
Oh, hello, this is a sound check. This is Amanda Finnis.
Yes, thank you. You're coming through fine.
Thank you, Michelle.
Thank you.
You're welcome.
All right, thank you, Michelle. It's now 4:36 and we are back on the record. Are we good to go, Denise?
Yes.
All right, very good. Ms. Collenbeck, if you would, please call your next witness. You're on mute.
My apologies. NextEra calls Amanda Finnis.
Please raise your right hand. You do solemnly swear the testimony you're about to give in the matter now hearing will be the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Thank you.
Would you please state your name and your business address for the record?
Yes, Amanda Finnis, and my business address is 700 Universe Boulevard in Juno Beach, Florida.
And by whom are you employed and what is your job title?
NextEra Energy Transmission, and I'm Executive Director of Finance.
Are you the same Amanda Finnis who filed direct and rebuttal testimony on February 28, 2022 and May 27, 2022, respectively?
Yes,
Do you have any additions or corrections to make to your testimony at this time?
I do not.
If I asked you the same questions again today, would your answers remain the same?
They would.
Chair Keen, I move the admission of the direct and rebuttal testimony of Amanda Finnis.
Is there any objection? Hearing none, without objection, it is admitted.
Thank you, and I have no further questions and will tender Ms. Finnis for cross.
All right, very well. Good afternoon, Ms. Finnis.
Good afternoon.
Let's turn first to the commission and see if they choose to ask questions first or defer. I'll turn first to Commissioner Duffy.
I will defer. Thank you.
Thank you. Commissioner French.
I have no questions at this time. Thank you.
Pardon that. Ms. Finnis, I do have a couple of questions, if we might. Let's take a look, if we can, together at the settlement agreement, in particular on page 10. Tell me when you have that.
I have that.
All right. Let's take a look at what appears to be, well, it's Roman numeral 2A10C. Very bottom of the page, over on to page 11. And I will read into the record what that provision of the settlement agreement states. It states, and I quote, NETE Southwest Indirect Parent Company, NextEra Energy Capital Holdings, Inc., it's niche in parens, commits that for the first 40 years of operation of the Wolf Creek-Blackberry project, NETE will provide or secure equity capital injections up to $10 million per year as needed to maintain the financial integrity of the project, consistent with an investment grade credit profile. Have I accurately portrayed that portion of the settlement agreement?
Yes, I believe so.
All right. So here's my question. So we have the NETE's indirect parent willing to contribute capital injections of up to $10 million per year for 40 years. That's the way I'm reading it. What form does this commitment take other than the commitment on this piece of paper right now? What do you anticipate going forward? What form will that commitment take?
I believe that the initial commitment of funding for the project was also made by NextEra Energy Capital Holdings. And I would suggest that a similar type of letter could be a potential opportunity for the vehicle for the commitment, although I'm in some ways addressing that question on the fly.
Okay. Does this commitment come with any guarantees?
Yes, I view the commitment as incremental to the other attributes of the project. To describe more what I mean by that, the initial funding or initial investment for a project of this nature is very important. And in this case, there's an expectation that the project benefits from to receive initial funding from NextEra Energy Capital Holdings. And once a project goes into operations, the expectation for the revenue of a project would be to address costs from a creditor's perspective, but also generate operating cash flow that are available as a source of capital to a project. And I view this as an incremental commitment to all of those other attributes.
Okay, so we have the security we're looking at here then is basically the credit worthiness of the indirect parent. Is that correct?
The credit worthiness of the indirect parent, I think, is a terrific credit profile. So the NextEra Energy Capital Holdings entity, and I provided more detailed facts in my testimony, but the credit profile of that company is the corporate credit ratings are A-, Baa1, and A- from S&P, Moody's, and Fitch, respectively.
Yes, and I respect that, and I take that situation at face value. I think we do that. We live in a post-Lehman era. We live in a time of great change and transition in so many aspects of our lives. So I guess my concern would be, what impairment risk could be present if for any reason that affiliated entity or its successor, perhaps we're talking about a 40-year period here, becomes unable to maintain an investment grade profile or perform.
So
however unlikely today.
Right. No, thank you. I appreciate that. I would refer, back to where I do believe that, it's inherent to project development, in particular major infrastructure project development, that the initial funding is an important part of the process. And so you have, once a project is operational, the expectation for its revenues, as I said, to, from a creditor's perspective, not only cover those costs, but also to generate operating cash flow. So the project itself really is kind of where I start in terms of financial profile. So in this case, I view, as I said, the commitments of NextEra Energy Capital Holdings as just incremental to what would be an expectation for a project to have an initial, the initial substantial commitment for funding from a creditworthy sponsor, and also then to be entitled, to operate.
All right. Does this commitment, I think the answer maybe, the question may suggest the answer may be so obvious, but I'm going to ask the question anyway. Does this commitment by this indirect parent apply to prevent financial performance for construction as well as maintenance and operation upon completion of the project?
So I think I've referred to two different commitments. One of them was with respect to the expectation of the project to receive its initial funding from NextEra Energy Capital Holdings. And then the second one, which I think is your more ongoing aspect of your question, is the one we've talked about from the settlement agreement.
And that you're in that latter case, you're talking about the operation and maintenance expenses. Is that what you're saying?
Right.
Okay.
The commitment of NextEra Energy to the capital structure as described in the settlement terms.
All right. Well, that concludes all my questions for the present anyway.
Chair Keen, could I
Yes.
ask one follow-on question to that line of questioning?
Absolutely.
I apologize. And my question is probably more fundamental, less theoretical, and it may even be a question to the attorneys in the room. We have a situation.
Busier in here, huh?
Sorry, I think IT is not on mute. Michelle, could you mute your line? My question is, we have a situation with a settlement agreement where we have a commitment from an entity that is not technically a party. And I don't believe NextEra Energy Capital Holdings is a signatory to the settlement. And so I guess my question is a follow-on to the question the chair had, which was, what form do these commitments take? Will there be separate documents executed that can be enforced? Because it doesn't appear that the settlement agreement would be enforceable against NextEra Energy Capital Holdings, who is making the commitment here but not signing the document.
Commissioner French, let me just make certain I understand. Are you asking, will there be separate documents that would be enforceable against NETE to put the settlement provision into play?
Exactly. How would this commitment be enforced against NETE if they are not a signatory to the settlement? And I may have asked an unanswerable question.
I think we can come up with an answer. We can just say letter. Yeah. We can certainly put that commitment in the form of a letter in addition to the settlement agreement, if that would satisfy the commission.
Yeah, that's something I would either like addressed in briefing. It's a legal question, either in briefing or in a separate document that all the settling parties feel is appropriate. Maybe that's attached as an addendum or filed in the docket. I will leave it to the parties' discretion to discuss this. I recognize it might take a little time to put together, but from my perspective, that seems to be a gap.
Thank you, Commissioner French. Yes, we'll certainly discuss it first internally and then with the other parties and potentially address it in briefing as well. Make certain we get something that's workable for the commission.
And if it's not a gap, that can be explained in briefing. That's fine.
I share Commissioner French's concern in this respect. His question is the absolutely capped. It's the follow on to the questions I was asking of you. And it really is the more pertinent question of any of them ask of either of us. So I share his concern there, and I would appreciate your addressing it. Commissioner Duffy?
Well, real quick, because I'm glad he raised it. I had that, but I would go another step. Where did we come up with the figure of $10 million as being sufficient? Is it? And if that's not spent, then does it just disappear? Does it go into a pool? I don't understand where the $10 million figure came from. Thank you.
I would address that where it is, in my opinion, a very healthy ongoing commitment given the scale of the project and with respect to what I see as what my knowledge of the project's ongoing requirements for operations.
Any further questions, Commissioner Duffy? All right, very well. Okay. That concludes the commissioner questions for the time being anyway. Let's turn next to Mr. Sakura, please.
No questions, thank you.
Thank you. Mr. Kimmel, any questions of this witness?
No questions, Commissioner.
All right, thank you. Ms. Kallenbach, if you wish to, do any commissioners have any further follow-up questions at this point? Commissioner Duffy, please.
Yes. So earlier, I believe it was stated that the total amount of of construction work was $16 billion last year. So is that 16 billion in a lot of projects, or is it there were some mega projects and by scale, this is very, very small? What is the normal size, or not normal, average size of a project, and what is projected for the next couple of years for NextEra in terms of spend for this sort of infrastructure building?
Yes, so subject to verification, I believe NextEra Energy was the fifth largest investor of capital across the U.S. In, I think the year I last have that statistic for would be 2020. So it is part of our business as to be a major infrastructure development with the scale of activity that you mentioned on a regular ongoing basis.
So the 80-some billion was an anomaly. That's what the performance has been. Is it increasing? A little bit more color on that, please. The 16
You're referring to the overall company's investment activity in a year and the trends in that.
Well, I believe it was the last conferee that spoke to the $16 billion being spent yearly on building, and how this was a relatively small project in the scheme of things. Or I guess this was Ms. Walding. I'm sorry. So can you shed any more light on, is this normal spending $16 billion a year for this company? And is the majority of the projects, are they small size, medium, or large?
I think something I can draw from my testimony to hopefully provide you what I believe you're looking for is the overall assets of NextEra Energy. I believe at year end were at roughly $140 billion. And in the context of my testimony, that came up with respect to the capabilities of the sponsor to develop and be an appropriate sponsor for the project. So I do think that the scale of development that you're referring to certainly has its ups and downs, but the company is consistently a major infrastructure developer with large investment opportunities along the lines you're referring to.
Okay, thank you.
There we go. Try and mute for a change. Ms. Kalmbach, pardon me. I believe it's your opportunity for redirect if you choose to use it.
Thank you, Chair Keen. I believe I just have one question.
Sure.
Ms. Finnis, thank you, sir. Ms. Finnis, do you recall a few moments ago, Commissioner Duffy asked you where the $10 million figure came from, how you arrived at that number?
Yes.
Would it be a fair characterization to say that the $10 million is designed to approximate the ATRR for the project?
I am not aware if that would be confidential information, but I assume that you're asking.
We confirm that it's public.
Okay, so yes, I agree with your comment.
Okay, thank you. I don't believe we have anything further.
Okay. Well, I believe, Ms. Finnis, I believe we've reached the end of your cross-examination. We appreciate your appearance before the commission today. Thank you very much for that. You are excused. You may step down virtually, and take care.
Thank you.
All right. By my reckoning, we have actually accomplished our primary goal for the day, which is to have cross-examination of all 5 of NextEra's witnesses. And coincidentally, it happens to be 4 minutes before 5 o'clock. I believe we're going to call it a day at this point. We will recess until 9 o'clock a.m. in the morning, at which time we will begin with the testimony of the Evergy witnesses, beginning with Darren Ives, and in accordance with the request of Ms. Kafer, that'll be followed by Kelly Harrison and then Steve Vetch. And then more to follow. We have a lot more to go through yet tomorrow. I want to thank all the parties today for your cooperation and aiding us in moving the hearing along. I think you all did quite well. We're very grateful for your responsiveness in doing that. So with that, I will bid everybody a good evening, and we are in recess. One other thing, parenthetically, the commission will hold its Thursday business meeting at 8:30 tomorrow morning, and then this hearing will resume at 9 o'clock promptly. Good evening to all. We're in recess.